reflected as when it was established, how many members you have and who you're representing?
Yeah, absolutely.
Thanks.
So one of the only document we've physically circulated this morning is a document we as a group produced last year. It's the Waipara Valley calendar, and in the back cover it has a little explanation about our group, which is partly why I thought it might be a helpful thing for you to see. We were set up in last summer, and the impetus for setting it up came out of these proceedings. But when we set it up, we had long discussions about what we wanted the group to be and what we wanted the group to do. And we were very clear that we wanted it to be a positive group and not a negative group, and that we didn't want it to be a single issue group. So as well as submitting in this process, we're looking at taking on and trying to bring a bit of life back into the Green Waipara project and looking for new sources of funding for that. And we're also looking at what other projects we can do to support our community, from things like setting up locals nights at a local winery, because Waipara doesn't have a pub anymore, and that's something people miss, to bigger projects in the future. This project today is probably dominating our time at the moment, but we do have big plans for other things in the future. In terms of membership numbers, so I'm in a slightly tricky position at the moment because we've got about sort of 20 fully signed up members, but a lot of other people who in the last couple of months through this process have come along to our meetings, joined, and we haven't processed their memberships yet. I'd say if we included those people, we're probably more like 60 or 70, but I can't really give you a number on that because, as I say, other things have taken over.
Okay, thanks. And I'm assuming you have authorization on those 20 signed up?
Yeah, so we have three three committee members. I have 3 committee members. I'm one of them, and yeah, we are representing the people in our group.
Okay, thanks.
2 preliminary items, says before I begin. You should now have 3 bundles of supporting documents from us. One is the preliminary bundle that contained documents relevant to the procedural issue you heard first thing on Tuesday. The second is a bundle of documents that were also provided on Tuesday, that bundle 1. And then you should also now have a third bundle that should have come through to you either yesterday afternoon or this morning, and I'll call that bundle 2. Can I just check you have those 3? Thank you. Oh, and the other bit of housekeeping, I have emailed this morning to Ms. Atkins a copy of the speaking note I'm using this morning and a copy of my speaking note from Wednesday last week. I have quite a long slot with you this morning, so I thought it'd be helpful at the beginning if I just give you an outline of the order that I'm going to take things in. First of all, I'm just going to speak briefly to the legal framework under the RMA and the activity status of the application, and then the policy framework, that is the consistency of the district plan with the MPS on renewable energy generation. I have a brief submission to make on the weight you should give to the applicant's evidence, and then I'm going to turn to the substance of the application, effectively the existing environment first, landscape effects, fire effects, and that's probably where I'm going to spend the bulk of my time this morning. And then I'll say, depending on how much time we have left after that, I'll address other effects, make some concluding remarks, both on the legal framework and the limitations of mitigation and conditions in this case. And then I have just some very brief closing remarks after that. So starting with the legal framework, I think I'm right in saying now that there is now a dispute between us and the applicant as to whether this needs to be considered under section 104D or section 104 of the RMA. That distinction depends on whether the Matagari clearance is within scope and whether it is a non-complying activity under the district plan. Now, the scope issue I addressed you on last week, so I'm not going to say anything more on that. If it is a non-complying activity, section 144D is the statutory threshold test that an application must pass. So in that case, you can only grant consent if you are satisfied either that the effects on the environment will be minor, or that you are satisfied that the activity will not be contrary to the policies and objectives of a relevant plan. Here it's the Hurunui District Council District Plan. And I will go on later to say where we say it fails on both limbs of that test. As I say, that's our primary position, that we're in section 104D territory in this case. But if you disagree with us on that, the application falls to be determined under section 104. We say it would fail, should not be granted consent on that basis either. And no, sirs, you'll be very familiar with it, so I'm just going to flag 4 things at the outset for the section 104 analysis. First of all, that subsection 1 tells us that effects to be considered include any actual and potential effects on the environment. Section 3 tells us that effects include any potential effect of high probability and any potential effect of low probability of high potential impact. Section 2 of the RMA tells us that the environment includes, among other things, people and communities and the social, economic, aesthetic and cultural conditions which affect them. And subsection 6 of 104 empowers a decision maker to decline an application on the grounds that it has inadequate information to determine it. That's a very quick run through of the relevant RMA provisions. As to activity status, we effectively covered this off on Tuesday last week, but just to complete the circle, we didn't on Tuesday get to the actual evidence on whether the Matagari is non-complying or not. This is set out in my preliminary written submissions. That's paragraphs 29 to 36. I'm not going to spend a long time on it because it's there and it's also a very straightforward point. The relevant question is effectively whether the Matagari was older than 20 years and of an area larger than 5,000 square meters. There is clear evidence before you on both of these, set out in our written submissions, which refer to that preliminary bundle of documents. In particular, says you have the evidence of Dr. Merck on both points. I should flag here that there is a conflict in the evidence between that of Mr. Kidner on the one hand and Dr. Merck and others on the other hand. We say Dr. Merck's evidence is to be preferred. Not only is he of considerable experience, it is supported by the witness statements of both Mr. Harris and Mr. McCaskey, and they are in that preliminary bundle. Ultimately, the weight of the evidence on this point is clear. It was older than 20 years. Dr. Merck estimates it was more like 200 years old, and the aerial photographs are clear. It was closer to a hectare than half a hectare. It follows from that that this is an application for a non-complying activity. So that brings me to the third thing I'm going to cover, which is what I'm calling the policy framework, the interrelationship between the National Policy Statement on Renewable Energy Generation and the Hurunui District Council District Plan. I think it's fair to say that following Ms. Al-Kamil's evidence last week, the applicant's position is that it is consistent, but there wasn't total clarity on that point, if I can put it that way. I say they are consistent with one another, but I'm going to go through both of them to make that point good. If I could ask you, please, if you have the National Policy Statement in front of you. If you don't have it, it is in our first bundle at page 1. I'll start, if we can start at page 6 of the policy statement. This sets out the objective and policies. And first of all, Objective 2.1C of the policy statement is to enable renewable energy generation, support the social, economic and cultural well-being of people and communities, and for their health and for their safety. So we see from the outset of the MPS that supporting the well-being of communities is at what the heart of the policy statement seeks to achieve, as is ensuring that renewable energy generation is developed safely. Those points I say are critical. We then go down to the policies. Policy A1 requires the decision maker to enable and provide for the benefits of renewable energy generation. And I've stressed the words "and provide for" them because that will be critical when we come on to look at the district plan. Policy A2 at points A to E effectively lists benefits of renewable energy generation that must be considered. F recognizes the temporary nature of some, and effectively G recognizes that it's good to locate REG activities both one, close to electricity demand, and two, close to electricity networks. And finally, A2H requires that decision makers must recognize that adverse effects of REG activities can be reduced by locating them, first of all, where there are other similar activities and other appropriate activities, and secondly, locating them where they will minimize adverse effects on other activities. In other words, says it is clear from policy A2H that location matters. Policy B then considers the cumulative gains and losses of renewable electricity generation. That's not directly applicable here. In my view, those provisions are best understood as being directed at authorities when considering zoning matters and not ruling out the ability for REG activities to be located in all zones. REG activities, of course, here including everything from community scale, small scale generation up to commercial scale generation. And come on to policy C. Again, it's a requirement that decision makers recognize this and do not require a specific assessment of alternative sites. But what I would just flag here that this policy does not do is require that wherever a functional and operational need exists, REG must be allowed. It is a factor, but it is one of the several factors within the policy statement that you are required to recognize. Policy D requires the protection of REG assets and activities from other activities. It requires they are protected, but note it does not say how that protection may be achieved. That is left to regional and district authorities. So part of that protection may be in appropriately locating REG activities so that reverse sensitivity effects don't arise. Policy E goes to recognizing and providing for Maori interests, and I don't understand there to be any issue around that. And then we get on to policy F, which I'm going to spend a bit more time on. First of all, policy F1, decision makers must enable REG assets and activities in all locations and environments. That does not mean that every application for a consent for a REG activity must be consented. I have three points to add on that to note. First of all, we've seen from policy A that it's built in to the policy statement that the location matters. Secondly, and I don't think I need you to turn it up at the moment. I'll just give you the reference. It's in our second bundle of documents at page 11, is an extract from the Ministry for the Environment's webpage about the policy statement. And if you look at the impacts of AMPS section on that website, it states, and I'm quoting, the MPS is only one of a number of factors that an RME decision maker must consider when making a decision on renewable generation proposals. the MPS does not promote renewable electricity at any environmental cost. And even Ms. Al-Kamil, in her evidence on Wednesday, accepted that the policy statement does not mean that every proposed solar plant application must be consented. Policy F2 then provides that where REG assets and activities are proposed to locate in or are likely to have adverse on the environments and values provided for in section 6 of the Act, that's matters of national importance, the provisions of the policy must be read alongside other relevant national direction, policy statements, regional and district plans. In other words, the policy statement doesn't trump section 6 matters. And as you will see, says as we go through the rest of my submission, I say this application does affect matters of national importance, section 6 matters, in at least 2 ways. First of all, section 6, subsection C, the protection of areas of significant indigenous vegetation, and subsection H, the management of significant risks from natural hazards. Policy F3 is then the one that I think attracted a bit of a discussion last week, and that's that where, first of all, to note where F2 doesn't apply, so where we're not in the territory of matters of national importance. In those cases, the adverse effects of REG activities and assets must, where practical, avoided, remedied, and mitigated. So it's inherent in that provision, says that the policy statement allows for the possibility that the adverse effects of a renewable energy generation activity may not be capable of being avoided, remedied, or mitigated. And what do the words "as practicable" mean? Well, I say, first of all, they reflect that fact, that it's an acknowledgement that it won't be practicable in all cases. But what do they mean for your decision making? As you know, says, if we're in section 104 territory, you have a broad discretion to conclude whether or not to grant consent or not. And I say what those words in the policy statement do is limit that discretion somewhat where REG activities are involved. Absent this provision, a decision maker may recognise that adverse effects can be mitigated, but nonetheless, in their discretion, choose to decline consent. The policy statement tells them in that case they should grant consent because mitigation is practicable. But as I say, it does not mandate granting of consent in cases where adverse effects cannot be mitigated, remedied, or avoided. Policy F4 then requires decision makers to have particular regard to the use of adaptive management measures. And particular regard here, of course, does not mean that you must conclude they are necessary or appropriate. It's something to consider. And policy F5 is another have regard to one. When considering residual adverse effects of REG assets and activities that cannot be avoided, remedied, or mitigated, decision makers shall have regard to offsetting measures or environmental compensation. So there may be cases where you cannot avoid, remedy, or mitigate, but offsetting is an appropriate response. F5 requires you to consider that. It does not require you to conclude that in all cases, offsetting or compensation will be the answer. And policies G and H, I'm not going to go through because I don't think there's any question that they're not relevant here. What does all of that mean taken together? I say that from the policy statement, you take the following. Consenting authorities must recognise the benefits of REG activities, must not rule out whole areas from the possibility of REG of all types, including small-scale REG activities. Decision makers must consider whether the location of an REG activity is right or appropriate. Decision makers must consider whether an application enables REG activities to be developed safely. Decision makers must consider the well-being of communities in part of their assessment, and must consider mitigation and offsetting as far as those are possible. It also allows for the possibility that they will not be possible. So that's a quick run through of the policy statement. There's one more policy statement I'm just going to make a very quick point about before I get onto the district plan. It's in our bundle again, bundle 2 this time at page 1. It's a very short point. It's the National Policy Statement on Natural Hazards. And the short point is simply that the policy statement on natural hazards to section 1.31 lists the natural hazards it applies to. That list does not include wildfire, but section 1.34 of the policy statement then tells you that the statement does not preclude decision makers from managing natural hazard risk beyond the application of the policy statement, including managing risks from other natural hazards and activities not otherwise covered. And so I think that's quite straightforward. It allows local, regional and district authorities to recognise if there are other natural hazards that may not be in the national list, but are of particular importance in their given regions. That brings me on to the provisions of the district plan. They are set out beginning at page 65 of our first bundle if you don't have them elsewhere. I'm going to start with objective 3.1. That is that the character and amenity values of rural areas in the district are maintained while providing for the activities, including those associated with other activities, including those associated with primary production. And then following through to policy 3.5. Policies to enable a variety of activities to occur within rural areas while managing adverse effects on character and amenity values. And it does that in part by seeking that the scale and the siting of the development first of all, maintain a dominance of open space and plantings over buildings. Secondly, maintain privacy and rural outlook for residential activities. At point 4, achieve an appropriate level of compatibility with this existing development in the surrounding area. And at point 7, are appropriate to the location, recognising the need for activities reliant on natural resource to be located where the resource is available. So the thrust of that objective and those policies is to recognise that activities, including rural-based industrial activities, that comes from 3.6.1, may all need to be located in the rural zone, but need to be managed so that adverse effects are mitigated, with location being an important part of how that happens. And that accords with the explanation that's given in the introductory marks to chapter 3 at 3.1 that recognises that non-primary production land uses such as infrastructure and renewable electricity generation have a functional operational need to be located in the rural area. So the chapter is recognising the need for activities including renewable energy generation in the rural area, and seeks to manage how adverse effects are avoided, including by location. And I say that accords with parts of the national policy statement that we have just been through. I take you next to chapter 7 from the district plan. That begins at page 115 in our first bundle. Just flag the very first introductory remarks at the beginning. Notes at the outset that under section 7 of the RMA, the council must have particular regard to energy efficiency, climate change, and the benefits to be derived from the use and development of renewable electricity. So that's upfront mandatory. The council is required to have regard to the benefits, and that exactly aligns with the requirement in the MPS to be aware of and to provide for the benefits. We then go down to objective 7.1. The development, operation, maintenance and upgrading of new and existing renewable energy generation activities is provided for while ensuring that conflicts between those activities and sensitive environments are managed. Again, that aligns with what we saw in the policy statement, to provide for REG activities, but manage the adverse effects. Objective 2.7, energy generation, supply and use from non-renewable energy sources are provided for, where adverse effects are avoided and remedied. And then policy 7.1 recognises the benefits of REG activities as the MPS demands that decision makers do. Policy 7.12 recognises that the benefits of energy production from renewable sources can be recognised, including by providing for community and commercial scale renewable energy production in less sensitive environments, that is those areas not identified in 7.6 and 7.7. Finally, on the policy section, policy 7.7 in the district plan requires consideration of environmental compensation or offsetting where effects cannot be avoided, remedied or mitigated. And of course, that aligns with what we've just seen in the policy statement at policy F5. I'm just going to speak briefly about chapter 13 in the district plan. That's ecosystems and indigenous biodiversity. Policy 13.2, just to flag, to protect areas identified as having significant indigenous biodiversity value by avoiding, remedying or mitigating adverse effects using appropriate mechanisms, including where identified through a resource consent process. Now, in respect of indigenous vegetation of over 5,000 square meters, rule 13.4.4 meets that policy objective by making the activity non-complying. So again, that accords with the policy statement at policy F2, that where section 6 matters are engaged. Here, significant indigenous vegetation, you read the MPS alongside other instruments such as the district plan. And the final chapter of the district plan that I'm going to ask you to look at, sirs, is chapter 15 on natural hazards. If it's easiest, it's at page 142 in our first bundle. Definition of a natural hazard in the district plan means any atmospheric or earth or water related occurrence, including earthquake, tsunami, erosion, volcanic and geothermal activity, landslips, subsidence, sedimentation, wind, drought, fire or flooding, the action of which adversely affects or may adversely affect human life, property or other aspects of the environment. So the point I make there is that fire is recognised in the district plan as a natural hazard, and that definition, incidentally, is the same as the definition of natural hazard in section 2 of the RMA. There's no conflict with natural hazards policy statement because, as I saw, it permits decision makers to list their own, to include additional natural hazards that aren't included in the MPS. Objective 15.1 is where the concerns around natural hazards are given effect and recognised in the district plan. Very straightforward, subdivision, use and development of land is enabled while avoiding, mitigating the adverse effects of natural hazards. And again, that accords with policy F2 of the renewable energy generation policy statement, but where section 6 matters are engaged, the policy statement must be read alongside other instruments such as district plans. So and my position is quite straightforward from those provisions, that the district plan and the policy statement on renewable energy generation activities are both seeking to achieve the same goal of enabling or providing for REG activities. Both recognise that adverse effects should be avoided, remedied or mitigated where possible, and both recognise that an important part of how REG activities are enabled is locating them in the right place, where adverse effects can be avoided, remedied or mitigated. That's the quick run through of the legislation and policy framework. Before I get on to the effects considerations, I'm going to make a short point says on the weight that we say you should give to the applicant's evidence or to some of the evidence. Of course, you'll be very familiar with the Environment Court's Code of Conduct for expert witnesses. Experts must not behave as an advocate for the party they are engaged by, must not omit any relevant matter that might detract from the overall opinion they express. And the Environment Court explained that in Blueskin Energy Limited and Dunedin City Council, the reference incidentally is in the speaking notes, so I won't read it out. The court said where an expert appears to take the position of an advocate, this compromises the weight of the evidence they give. So as I say, that concern applies to the weight to be given to both the evidence of Ms. Al-Kamil and Mr. Cocker that you heard last week. Taking Ms. Al-Kamil's evidence first. We begin with the failure to include the Matagari in her assessment of environmental effects right back at the start of the application process, and the failure there to recognise that relevant rules of the district plan were engaged. Also in that AEE, she initially identified only 3 properties as being affected and recommended on that basis that there should be limited notification only to 3 properties. I say in light of the evidence that you have heard, that is obviously a flawed assessment, if not a straightforwardly biased assessment. Her AEE omitted the critical issue of tourism, as did her statement of evidence. And you recall that is one of the most frequently raised concerns in submissions. I refer back to the Environment Court's note. One of the requirements for expert witnesses is they do not omit relevant matters. I would also say, sirs, that when you heard her evidence last week, she did advocate, she did act as an advocate for the applicant. And I would say that was particularly the case in response to her questions from you on Wednesday morning. Overall, in my submission, she has taken a position as an advocate for the applicant within this proposal. And then in following the approach taken in Blueskin, you cannot safely give much weight to her evidence, certainly not the weight of an expert. I'm turning to Mr. Cocker. There is a similar failure, as you have noted and identified, to recognise that there was Matagari on the site, despite the fact that it appearing in photographs in his initial landscape assessment. You have yourselves raised questions as to the scale he used to assess effects, and in particular the fact that when he changed his methodology somewhat, the conclusion he reached didn't correspondingly change. In paragraph 95 of his witness statement, and I believe this was in response to a question you asked in one of your minutes, he gives an example of native planting in the nearby area, which he says he understands was not irrigated. That conflicts with the direct evidence you have of 2 submitters you heard from last week who had personal knowledge of it being irrigated. That's Ms. Richards and Ms. Lee May. Overall, sir, I say with Mr. Cocker's evidence, there is a similar concern to Ms. Al-Kamil's, and that you should therefore treat his evidence with caution. And we have a conflict in the evidence between Ms. Annan and Mr. Cocker. I say the better approach is to prefer Ms. Annan's evidence where these difficulties simply do not arise. Finally, on weight, Mr. Andrews. Mr. Andrews includes in his statement of evidence the standard expert declaration, but of course he is not an expert. He is the voice of the applicant. He is very much an advocate for the applicant. Now here I'm going to make a short point on the developer's background. I say it is relevant to your consideration of parts of this application in 3 ways. Firstly, there are parts of this application where we only have the applicant's own evidence and not that of an expert. So the background is relevant there. Secondly, it may be relevant when you come on to consider whether a bond is appropriate. And finally, it helps to understand what might otherwise seem inexplicable. So I'm just going to do this very briefly. There is a precise overlap in the control of this applicant and a company called Supercharge Limited that was previously received an official warning from the Commerce Commission specifically about making unsubstantiated claims about solar energy. There it was in the context of rooftop solar. And it was implied by the Sustainable Energy Association the company was disreputable. By precise overlap, I mean they have precisely the same shareholders and precisely the same directors. The documents are in our bundle. The references to the relevant parts of the bundle in my speaking note. It's pages 348 and 356. And the concerns are also summarized in an article that appeared in the press, and that's at bundle 1, page 432. That's the start of the article, and the relevant part is 439. I won't push that point any further, other than to say that perhaps it does help us to understand what otherwise may seem very strange, how a development of such significance as this application could have so many problems and to have got to this stage that mitigation just isn't possible. That, I think, is not what one would normally expect, but it is the case here, and perhaps the background helps explain why that is not so surprising. Turning then to landscape, and to begin with the existing environment and perceptions of the existing environment. And we broadly concur with Ms. Anand's evidence on this. And you've heard a lot from submitters on what the landscape means to them and the values it holds. And we say that that broadly aligns with Ms. Anand's evidence. I'm not going to repeat the points you've already heard from many submitters last week about landscape, other than to say that the values you heard expressed by those submitters reflect the values that our members also hold. Because we're a collective, I can't give you a single answer on what the landscape means to us, because different things are important to different people, but it very much accords with the evidence that you have already heard. Just to address some specific points, I think at times it's fair to say last week we had a fairly lengthy discussion of whether a solar plant of this type is an industrial, rural or utility activity. I've been thinking about this over the weekend and I've come to the conclusion that I think it might be one of those things that shies away from precise definition, but very much falls into the category of you know it when you see it. We all know instinctively what a rural activity is. Solar energy generation doesn't have to happen in rural areas. Christchurch Airport is an example of that. And just because something can happen in a rural area, that doesn't in itself make it a rural activity. And the analogy I've been thinking about over the weekend is that many people living in urban areas in the city grow vegetables in their garden. That doesn't make the growing of vegetables an urban activity. Just because it occurs in a rural space, it's not necessarily a rural activity. Mr. Preston, I would say, put it very well. If it is a utility activity rather than an industrial activity, then it is a utility activity on an industrial scale. And you have heard comprehensive evidence that this application is not perceived as rural and is not something that the people who live in this community would expect to see in a rural area. Ms. Al-Kamil in her evidence suggested that perceptions may change over time, effectively that people may get used to seeing solar generation of this sort of scale and renewable in rural areas. The first thing to note there, of course, is that people can get used to anything in certain circumstances. That doesn't mean that it's right that they do or that they should. The other thing is that there might be the case that perceptions in fact change in the other way. I mean, we've included in a second bundle of documents at page 26 a research article from a scientist at Vanderbilt University in the United States. It's entitled "Solar Farms and Opposition Groups: Assessing Alternative Sustainability and Anti-Sustainability Perspectives on Their Discourse." Now, I'm not going to take you through the detail of that, I would include it just to say it begins from the premise on the basis, as it's set out in the first paragraph, that where there has been an increase in solar generation activities in the US and in the UK, opposition to such activities has in fact grown. It has not, as Ms. Al-Kamil was suggesting it might, decrease. It has gone in the perception has changed in the other direction. Of course, at the end of the day, what matters is perception now and not what it may be in the future, and you have heard clear evidence on that. You've heard a lot of evidence on explaining why vineyard trellises are fundamentally different to rows of solar panels. I'm not going to say anything more other than we agree with what you've heard. Vineyard trellising is a structure that is covered in nature, it's alive. It is not a man-made structure such as a row of silicon panels. As to what effect the proposal would have on the landscape, the overall effect is to fundamentally change the character of the area. You heard that from many submitters. You will recall from Ms. McGaw our evidence that Waipara Valley is a small basin. We are quite a small valley and we are enclosed by hills on all but the south side. Ms. Naish told you that this solar plant will be visible from Mount Cass. Waipara is, by its geographic features, a small valley, and this proposal would dominate it. It would result in the loss of open space and of views, the replacement of pasture with man-made structures, and indeed the applicant implicitly acknowledges the adverse effect on the landscape of the proposal. And that is why it is said from the outset that screening is so important. Screening, it is acknowledged, is essential. Well, as to screening, and both the screening and the native planting, in fact, previously heard from me on the issue of water. That is critical. Water is critical to irrigation. Irrigation is critical to the success of screening and the native planting. But even if water can be found, what evidence do you have that the planting can be done and can be done well? I say you have none. Recall you have Mr. Priest's evidence as to the difficulties of planting on this site. And also, for your reference, in that first bundle at page 343, the news article about the applicant's failure to achieve the native planting that it undertook in relation to a 22-hectare solar plant that it has in Edgecombe. And the point I'd note there is, if it has had difficulty achieving the native planting on a 22-hectare site, what difficulty might it have on a 180-hectare site, which Mr. Priest acknowledges is a difficult site. The other point to note is that it still, even at this stage, remains unclear if the native planting is being proposed as offsetting for the clearance of vegetation on the site, or if it is to provide mitigation for the adverse visual effect. That's the softening that's being referred to. Rather appears to be Schrodinger's native planting. It Depends what it is, depending on how you're looking at it. A comment on the temporary or not nature of the adverse effects. In my submission, the adverse effects that will exist prior to screening planting being established are not temporary when you consider them against the lifespan of the proposed infrastructure. This is not infrastructure that will last for hundreds of years. This is panels that will have a lifespan of 25 to 30 years. You have heard ample evidence that the growth rates relied on by the applicant are simply not realistic in Waipara. Recall in particular the evidence of Dr. Merck, who told you that for natives, you may get a growth rate of 10 to 30 centimetres per year, depending on species. In addition, you have heard that shelter belts are vulnerable to be knocked down in high northwesterly winds, particularly if they are grown fast. There is a real risk here that screening is planted and established only to be lost, in which case the adverse effects of the visual impact of the proposal will never be mitigated. They will exist throughout its lifetime. A quick point on the permitted baseline. Of course, it's right that shelter belts can be planted, but I say it is fanciful to suggest that absent an application such as this, a farmer will plant shelter belts around the entire perimeter of the site. And that's particularly so because of the issue of water. We've heard how hard it is to obtain and how beneficial it could be to farming activities on the site. It is purely fanciful to suggest that a farmer could get irrigation that it would need for screening to the extent proposed here and choose to use that to screen the entire perimeter rather than to use the farm in a more productive way. We concur with Ms. Kirby's conclusion in her section 42A report at paragraph 138. She states there that it's her opinion that while some weight could be attached to the permitted baseline, her view is the proposed boundary screening is not for the primary purpose of providing wind shelter and does not fall within the definition of a shelter belt. She does not consider it provides a credible permitted baseline given the proposal includes landscape screening around the boundary perimeter as a whole. And she is not of the opinion that a property owner would undertake a similar level of shelter belt planting to provide wind shelter to the site. A point to remember that I think may tend to get lost is that screening doesn't remove the adverse effects here. It just changes them from seeing the industrial site as it would be without screening to losing the current open and scenic view from State Highway 7. It is replacing one bad view with another bad view, both at the loss of what is currently an exceptional view. And of course, even with screening planting established, the solar plant would still be seen from State Highway 7. Recall there are going to be 4 access points along there. They are not going to be screened. 3.5 kilometres along that road would be a stretch of screening planting interrupted with views of the solar plant. A final point on, brief point on landscape effects, something we've included in the bundle for you, so it's in our second bundle at page 127. And that's several examples in there of house sale listings and advertisements for renewable, for retirement villages in Amberley that all boast that they're located at the gateway to the Waipara wine region or similar language. Can you seriously imagine such an ad boasting about that a retirement home is at the gateway to a renewable energy generation hub? It's simply not credible. And so I'm going to turn to fire now, and I'm going to spend quite a bit of time on this. As you have heard, it's a serious concern for many submitters. It's a serious concern for members of our group. I therefore need to address it at some length, and I'm going to ask you to turn up the documents because the details are important. At the outset, I ask you to recall the Section 3 RMA definition, that the effects for you to consider include any potential effect of high probability and any potential effect of low probability, which has a high potential impact. Now, there are three separate issues around fire. The first is the risk of the solar plant starting a fire. The second is the risk of fire entering the plant from elsewhere. And the third is the effects if there is a fire in the plant from any source. That's a fire that starts in the plant or a fire that gets into the plant, and the risk of toxic fumes that creates. So if we could begin, please, with Ms. Kirby's Section 42A report. She addresses fire beginning at paragraph 185. And I can give you the page number, and that's page 25 of the Section 42A report. So first of all, paragraphs 185 to 187, and she explains that the applicant provided a report from Becker that had been produced in regarding the solar plant it has proposed in Greytown, and it had provided correspondence with FENS, and that it then later provided a report by the Renewable Engineering Group, and that report was entitled FNSF Waipara Solar Farm Fire Emergency New Zealand FENS Supporting Report. Ms. Kirby notes at paragraph 188 that the REG report confirms and details why the applicant considers the conclusions reached for the Greytown Solar Farm are transferable to the Waipara Solar Farm. So the note there is that the REG report is not a fire assessment or a fire risk assessment of the Waipara proposal itself. It's simply a consideration of whether you can transfer the Greytown proposal across. Ms. Kirby does note in paragraph 188 that there have been changes to the screening vegetation since the REG report was created, and that the surrounding environment there does not include reference to the Waipara township. Paragraphs 189 to 192, Ms. Kirby's report summarizes the parts of the Becker report and the REG conclusions, and I'm not spending long on them there because I'm going to take you directly to the underlying documents in a moment. And at 193, Ms. Kirby identifies that the main limitation of applying the Becker report to this application is in relation to grass fire, and that risk depends very much on the local climate. At 193 to 194, Ms. Kirby addresses how the REG report deals with the fact that the Becker report was not written for Waipara, and reaches the conclusion at 195 that based on the information provided by the applicant, fire is a risk that with appropriate site design, infrastructure choices, implementation and management, she expects could be able to be suitably managed. And she goes on at 196 to 197 to note the mitigation measures incorporated in the site design as described in the REG report. And she notes that the applicant has consulted with local FENS senior risk advisor on the proposal, who had reviewed and signed off on the site development plans. Finally, at 197, she concludes that her understanding is that solar farm resource consents commonly include conditions of consent to manage fire risk. Just a pause and a slight side note there at the beginning of paragraph 197. There are on occasions in Ms. Kirby's report references to her understanding. problem is that Ms. Kirby doesn't tell us what her understanding is based on. That makes it very hard to understand whether to know whether we can transfer that understanding to the present case. Just a point to note. The final point in the section 42A report I need to cover off on Ms. Kirby's consideration of fire is at paragraph 253, and that's in a section of the report headed leach-shaped breakage, toxic gases and toxic elements. And Ms. Kirby concludes that in terms of leaching to air through fire, I have considered fire risk above and have considered risk of fire can be adequately mitigated through appropriate conditions of consent. So it says Ms. Kirby's conclusions in her section 48 report are, as we have seen, predicated and based on the information provided by the applicant, and that's the Becker report, the REG report, and emails and correspondence with FENS. I can start then with the Becker Greytown report, and you should have it through the council website. I'm going to ask you to turn it up. I'm going to go through it in some detail. Just begin by noting on page 4, we are told at the bottom of page 4 who the report was prepared by, who it was reviewed by, who it was approved by. Section page 5 in the executive summary. First paragraph explains that it was provided for the Environment Court proceedings regarding the Greytown solar proposal. And then in the second paragraph, it tells us that risk is the combination of probability and consequences which are contingent on the specific fire development. So the risk is looking at both the likelihood and what the consequences would be if the event happened. Then take you down to page 6. Under the bullet points on that introductory page, the Becker report tells us that the focus of the assessment is the consideration of fire risks posed by the solar farm to the surrounding rural context. Assessment of the fire spread from the rural context of the site to the proposed solar farm has also been considered. So the point to flag there is that it very much depends on the rural context, and the rural context the Becker report was looking at was Greytown, North Waipara. Could go down then to section 2.3, and this is headed methodology. And again, those opening paragraphs recognize the second paragraph, low probability, high consequences events, low probability, high consequence effects, such as a fire can pose a greater risk than more common but lower consequence events. Over the page at section 2.3.2, the first point in the process that Becker followed was to define the exposed target that will be the subject to the harm or loss if the risk eventuates, i.e. what is being exposed to the risk. That is the first part of the assessment. And of course, in the Becker report, it was properties in Greytown. But down under point 5, under the bullet points, that's then made clear. Following the assessment, the fire risk relative to the current pastoral farming land use on which the solar farm was proposed was summarised. So what the Becker report did, which you'll see when we come further on, was look at what fire risk the solar proposal would create and look at the risk that already existed in the current rural context. But that's the current rural pastoral context of Greytown. 2.4 on the following page, an explanation of the target. Again, the exposed target must be identified so that the hazards and risks can be identified. And they understand that the exposed target is the local environment around the solar plant. Section 3 of the report sets out reference materials. I don't need to spend any time on that. And then we get at page 11 onto section 4, which describes the solar farm installation. And so the first point there is, as you can see, there's a visual. The area of the solar farm is marked in blue. You can see there are some scattered houses scattered around the vicinity, and the land is mostly pastoral. I understand, she says, you will also have a copy of the Environment Court's decision in Greytown. I don't think you need to turn it up, but I'll just give you the references. Paragraph 15 of the Environment Court's decision in Greytown shows a similar aerial photograph. And then at paragraph 18 in Greytown, the site is being described as approximately 5 kilometres away from the township of Greytown. The rest of section 4 deals with the specifics of the solar plant. I don't need to go through them. If we could turn to section 5, and that begins on page 22 of the Rebecca report. This is section 5, firefighting policies and procedures. The first point to note is in the middle of the page, 3 paragraphs under the bullet points. It's a description of FENS's firefighting approach towards solar farms. FENS noted that its current default position is to treat fires at solar farms in a similar way to how it treats fires at electrical substations. It will mobilize to the site and wait at the site entry until met by a site representative, enter the site when it is advised it is safe to enter, and undertake firefighting activities after electrical hazards have been mitigated. A site representative will be required to advise FENS which assets to protect and handle media inquiries. And FENS noted that a site representative is expected to be able to attend within 1 hour. Although 2 paragraphs on from that, we're told that if there's a predetermined plan, the officer in charge may choose to enter prior to the arrival of the site representative. And that penultimate paragraph on the page, beginning of the second sentence, Becca tells us, based on plans developed for other sites, as other solar sites, firefighting activities would most likely be limited to containing the fire within the access tracks that double as fire breaks. Firefighters will not conduct firefighting on or beneath the arrays. So FENS's policy is quite clear. It is containment, with no attempt to put out fires on or under panels. Go down then to section 6 of the Becker report. Section 6.2, first of all, deals with hazards during construction. 6.3 during operation. These I will come on to the summaries from this material, so I'm not going through it, not pausing on it here. But then we get down at 6.5. So the last part of the section 6 analysis is screening planting. And Becker notes that it understands the primary purpose of the screening planting is to reduce the visual impact of the solar farm, but that by meeting that primary purpose, a new fire hazard and new resulting risk is introduced. The screen planting is located in the 5 to 6 meters buffer zone between the property boundary fence and security fence. Those trees increase the fuel over pasture grass, particularly if they include any dead or dried material. And we'll come on to see how that feeds into the assessment. Section 4 summarizes the various fire arising scenarios that were considered. That's different sources of potential ignition, both within the site and elsewhere. And then at section 8, we have the risk characterization. And so the section 8 refers back to the scenarios that have been set out in section 7. And I'd ask you to pause on section 8.3.2. And this 8.3.2 is concerned with the scenario where a photovoltaic panel is the source of ignition. Becker identifies at section 8.3.2 that although the possibility of ignition and fire for a single PV module is low, the overall probability is much greater due to the number of panels that are installed across the areas. And given the 35-year or more lifespan of the farm, conclusion is that it is likely that there will be a PV module fire throughout the lifetime of the plant. Under the bullet points then at the beginning of the next page, Becker explains why, despite the fact that a fire is likely to occur, it's not expected to be serious. And we see at the second paragraph under the bullet points beginning, however, they note that if a fire does spread from panel to panel, that is only likely to occur along a row of panels, as the panel rows are separated by approximately 6 meters. I can note that the 6 meter separation between rows, that relatively large distance, along with the small load in the panels themselves, reduces the fire risk of spread by radiation to modules in adjacent rows. Section 8.5 of Becker report then considers fire from a grass fire being the ignition source. And I ask you to note, sirs, on page 39 of the report, there are 2 photographs that I think you'll find helpful when we come on to discuss the specifics of the application in Waipara. The 2 photographs at page 39, sorry. Top one shows fire where the grass height is 240 millimeters, and the bottom shows grass fire where the grass height is 100 millimeters. Over the page then, on page 41, next point to note, this is under 8.5.2, is there's a diagram showing the typical spread of a fire relative to the prevailing wind direction, or to the wind direction that's there when the fire occurs. And you see from the diagram at the top of page 41, it's elliptical. So the wind direction is along the center horizontal axis, and the fire spreads out in an elliptical shape around that. We then go down to section 9 of the Becker report. We have tables which summarize the conclusions Becker reached in relation to Greytown. 9.1, first area considered is fire risk during construction. And the conclusion is at the bottom underneath the table. the probability of fires is greater during the construction of the solar farm than it is in the surrounding rural context. But the Becker report considers that with appropriate management conditions, it can be brought down to a comparable or better level than the surrounding rural context. A point I would note there is that, first of all, it refers to conditions being produced. We have not got conditions from Greytown yet, as I understand it. They are still at this stage being in the process of being worked through, so we don't know what that realistically looks like. The second thing to note is that Becker is comparing the risk of the solar plant to the risk of the surrounding rural context. We must remember that surrounding rural context was Greytown. It's not comparable necessarily to Waipara, particularly where Waipara is a region where people who live and work here know of the particular risk of fire and know how to manage it. They alter their activities when the climate is particularly and the conditions are particularly dangerous for fire. So we cannot necessarily translate the conclusions about the rural context in Greytown to the conclusions about the rural context here. And then at 9.2, we have the conclusions on fire risk during operation. So again, the surrounding rural context is Greytown, not Waipara. And I should say on the fact that in Waipara, people change their activities, know to change their activities when the fire conditions are particularly dangerous. I should add to that that FENS, of course, routinely engage in public information campaigns around that, encouraging people not to engage in activities that could cause a fire, and be it that cutting the grass with a tractor, anything that could create a spark. So the rural context here is with rural context where people know and manage the risk of fire when that is necessary. Second point I would note on the table at 9.2. In the box under the heading smoke plume, sorry. Becker states that research indicates solar farm fires typically involve a single item, and we've seen how there's reference been to the spacing between the rows in regard to that. But also it notes that smoke plumes from a fire may contain toxic materials through the burning of plastics and other materials. I don't think there's any serious question that solar panel fires, if they occur, do create toxic fumes. But for your reference and for completeness, we've included in our documents, and I don't think you need to go to it now, but we've included a document entitled Photovoltaics and Firefighters Operations Best Practices in Selected Countries. It's produced by the International Energy Agency. It's in the first bundle at page 290, and there's a table in there at page 295 that explains that to minimize firefighters' exposure to hazardous chemicals from photovoltaic modules that are on fire, the best practice is identified as firefighters wearing personal protective equipment, including self-contained breathing apparatus. In the rural context, surrounding rural context analysis that Becker does at 9.2, it notes that, of course, a fire from a residential or vehicle fire may also well contain toxic products. The difference, of course, is that ordinarily FENS will attempt to put out a vehicle or residential fire. Imagine the fumes that would be created if a 180-hectare area of housing, for example in Christchurch, were left to burn, and the fumes that would be created if no attempt were made to put it out. That is the scenario here. Becker's conclusion on page 47. that the probability of a fire within the solar plant is greater than the surrounding rural context, but the overall risk is no more than the surrounding context, which also contains fire risk. Again, my point here is that in Waipara, we can manage solar risk and we know to manage solar risk. Of course, unlike a farmer who can tailor his activities appropriately to the conditions, particularly on dry and windy days, solar panels can't be removed when the risk is particularly high. Unlike the activities of a farmer, the activities of the solar plant, that risk is going to exist the entire time, whatever the conditions. And then the last table of conclusions Becca creates is at 9.3. And this is fire risk from screening planting. Concludes that the probability of screening planting fire is likely to be greater in the surrounding rural context, given the greater number of plants involved. But again, this is for Greytown. It doesn't consider Waipara, and it doesn't consider the extensive planting that is involved in the current application for Waipara. So those are the primary conclusions that Becca reached. The overriding point is that all the way through the analysis, the context matters. It's fundamental to their analysis. One last thing I'll do while I'm with the Becca document is if I can ask you to turn a couple of pages over to Appendix A. It's at page 51. And this is Appendix A, benchmark against CFA design guidelines. These are guidelines that are produced by the State of Victoria Country Fire Authority in Australia for renewable energy facilities. We'll also see when I come onto it in a moment that they're the guidelines FENS uses as its starting point. The whole CFA guidelines document is included in our bundle. It's bundle 1 at page 199. But the Becca report here summarizes the key recommendations from it. So I don't think you need to turn up the whole document. We can work through it in this one. See on page 52 and then over onto page 53. What the Becca report does is summarize in the left-hand column the generalized recommendation or requirement from the CFA guidelines, and then in the right-hand column assesses the Greytown proposal against them. So I say it's helpful that we do the same thing, but measure the recommendations against what we have proposed in Waipara. So the first one at the bottom of page 52 concerns facility location. And you will see the CFA recommendation or requirement is that renewable energy facilities are to be located in low-risk environments wherever possible to reduce the risk of external fire impacting the facility and its consequences. CFA considers indicators of a lower risk environment include grassland. And then second bullet point on the top of page 53, they include environments where there is no continuous other vegetation types within 1 to 20 kilometers of the project. Pausing there, of course, in Waipara, we do not have a site that is surrounded by grassland, as the CFA guidelines recommend, or as Becca was considering with the Greytown proposal. We have a site that is bordered in large part on one whole length, 4 kilometers or so, by vineyards, and that is the downwind side. If I could ask you briefly, we'll keep the Becca report open, but also to turn up so you can be looking at it, the site plans Mr. Andrews appends at Annex 1 to his witness statement. If you could look at the first of those site plans, please, sir. And this shows almost the entirety, I think if you zoom out, it does show the entirety of the site and the township and surrounding properties. And in the top right-hand corner of the key, you will see it's a due north document. There's a compass rose in the corner there. So you can see the prevailing wind coming from the top left corner of the document across the solar plant, with vineyards on the Mackenzie's roadside downwind of the prevailing norwesterly wind, and the township of Waipara also downwind of the prevailing norwesterly wind. Recall that elliptical fire shape that we saw when we looked at the earlier part of the Becker report, how it's an elliptical shape around the wind direction. Going back to the table of CFA guidelines on page 53 now of the Becker report. The second bullet point of in the column on the left, the CFA guidelines. The recommendation from CFA is for generally flat topography, although some undulation may be present. Back again to those site plans we just looked at. This time in particular, if you could look at first and second site plans. The yellow lines you see on those site plans, they are the slopes. The yellow lines are the slopes. It's quite evident from the site plans that it is not a generally flat site. There are numerous slopes and terraces within it. I should add, those slopes and terraces include, as you've seen, steep scarps at some parts on the Mackenzie's Road, so that is on the downwind site, and those steep slopes will be between banks of panel arrays, and they would be loaded with fuel in the form of native vegetation. The final bullet point on the facility location in the CFA guidelines. Good road access with multiple routes available to and from the project site. The only route to this site is State Highway 7. There is no road access to the downwind side of the site. Coming down then to facility design. And the first point there, provide a perimeter access road. Here there is a perimeter internal track, but as I've just said, the only access into the site as a whole is from State Highway 7. Don't need to go through firefighting water supply because I think these provisions have been met in respect of Waipara, so I don't have anything to add there, or for detection or suppression. I would pause please on page 54 under the heading Landscape Screening and On-Site Vegetation. The recommendation is that a fire break must be established and maintained around the perimeter of the facility and the perimeter of the substations and buildings. These must have a minimum width of 10 meters and avoid ignition of on-site infrastructure. I'm not going to ask you to turn them upside because in my experience, they take a very long time to load these documents. But if you look at Annex 5 to Mr. Andrews' witness statement, and that's his road drawings, you'll see that the perimeter zone, what's described as the perimeter zone in this case around the site, is 10 meters total width, but that 10 meters includes 4 meters of planting. So the distance from the edge of the planting to the first panel is only 6 meters. And at the bottom of page 54 under the heading Solar Energy Specific Requirements, solar energy facilities are to have a minimum 6 meter separation between solar panel banks. We have that here, we have 6 meters between panel banks, but we have separation of only 2.6 meters between rows of panels. And you recall Becker's conclusion that fire risk, if a fire is started in a PV module, would be unlikely to spread from one row to the next. That conclusion rested on the basis that in the Greytown proposal, there was 6 meter spacing between rows. We are at less than half of that. We are at 2.6 meters. And finally, on page 55, under the heading Vegetation Management, the recommendation is that solar facilities must have grass maintained to no more than 100 millimeters under solar panels during the fire danger period. What is proposed here is that limits on grass growth, first of all, are average maximum heights, an average maximum of 200 millimeters from December to March, and 300 millimeters from April to November. Now, an average standard, of course, means that some grass will be longer than that. So there will be some grass that is longer than 200 millimeters. For starters, the 200 millimeters is double the CFA guidelines of 100 millimeters, but also remember those photographs we saw earlier on in the Becker report of the difference in fire height between a 240 millimeter grass height and a 100 millimeter grass height. The other thing on vegetation management is, of course, this proposal involves putting extensive native planting and screening within the site that is to be 4 to 5 meters high. So it says, to summarize some key points that we have seen from the Becker report and those guidelines. The first is the obvious one, that the Waipara proposal does not comply with the key components of the CFA recommendations. Those are the ones we've just been through. The second key point to note from the Becker report, to identify the fire risk, you need to start with identifying the exposed target, what exists in the surrounding area. That was Becker at section 2.4. Direction of grass fire is elliptical around the wind direction. That's at 8.5.2. And FENS's policy is containment. FENS will not attempt to put out fires on or under panels. That's at Becker 5.1. While the probability of a panel starting a fire is low, given the large number of panels and the plant lifespan, it is more likely than not that a panel will start a fire over the course of its lifetime. That's Becker 8.3.2. Vegetation height has a significant impact on fire height. That's those pictures at 8.5. That takes us to the end of the Becker report, everything I need to look at there. If I could ask you now to turn up the Renewable Engineering Group report. This should be on the council website as well. And you'll recall from the section 42A report, and you'll see as we go through it, the purpose of this report was to say that effectively the conclusions of Becker in Greytown are transferable to Waipara. So just starting on the front page, I just ask you to note, sirs, the subheading. It's FNSF Waipara Solar Farm, Fire Emergency New Zealand, that's FENS supporting report. Just to be clear, this isn't a FENS report. It isn't a report provided in conjunction with FENS or produced in conjunction with FENS. It is a report produced by the Renewable Engineering Group. Page 2 is the contents. Then what you'll note, and you recall when I went through the Becker report, I asked you to note that that very first page showed us who it had been prepared by, reviewed by, and approved by. It was presented as well as evidence in Greytown. Presumably when it did so, the person who prepared it set out their qualifications in a statement of evidence to the court. The thing to note here at the outset with the REG report, no author is named, no qualifications are given. The executive summary on page 3 tells us the report focuses on evaluating the principles and conclusions reached in the Becker report for Greytown, and it demonstrates how those have been applied to Farnell's Waipara soil proposal. Section 2, we get the background to the REG group. And we are told that they're engaged by Farnell's solar farm to support the engineering development life cycle of its New Zealand solar development portfolio. And then the last paragraph on the page, that it has taken the lead in considerations in line with FEN's framework and in close collaboration with FEN's. Then go on the following page to section 3, methodology and standards. The last paragraph on the page states, while the Becker report was prepared to support a solar farm development in Greytown, the similarities in the design elements and receiving environment of that project and those of the Waipara solar farm provide confidence, in REG's opinion, that the conclusions of Greytown are highly transferable to Waipara. Goes on to say these similarities are considered below. So it does that at pages 5 to 6. And I'm just going to go through those quickly and highlight a few that stand out. So the first 3, yes, there seems to be identical proposal between Waipara and Greytown. Pause on number 4, module row spacing. This is the point I've already made. In the Waipara proposal, there will be a 5-meter pitch between rows, 2.6 meters at the flat position compared to 6 meters in Greytown. That's a significant difference in my submission. And point of completeness on that, again, I don't think this is a document you need to go to. The reference is our first bundle, bundle 1, at page 260. We've included there FENS's design guidelines for fire operations for emergency vehicle access. If you look at section 4.2 of that document, you see that for FENS vehicles to have access, the minimum width they need is 4 meters. So if you're looking at those site plans from Mr. Andrews, FENS would not be able to access any space between the rows. It would only be able to access the perimeters. Now, I've done a very preliminary look at the size of some of those panel banks. They appear to be in the region of 25 hectares. So FENS can only access the perimeter. It can't access anywhere in between rows of panels in those banks. If we go down to the bottom of that page, the vegetation screening that's proposed. Note that in the Greytown proposal, it was selected from a FENS list of approved species. That's the low flammable species, but not the case here. Then on-site vegetation, page 6. In Greytown, existing trees on the site will be removed. Quite straightforward. And I say that accords with CFA guidelines that you don't want vegetation within a solar farm. For Waipara, however, we are told existing trees on the site boundary will be trimmed to 5 meters. Other trees, bar a few natives, will be removed. That's the shelter belts that currently cut across the site. But we are told some terrace areas will be regenerated in natives selected from a FENS approved species list. So we rather than removing vegetation and fuel load in Waipara, we are adding it in. If you go down then to section 4, we were told first paragraph under section 4, fire and emergency NZ consultation, that the site design features relating to fire risk and mitigation at Waipara Flat Solar Farm were reviewed with Bruce Irvine from FENS, and the suggested design changes were approved by Bruce and are included in the paper. And I'm going to come on to show you what those were, what the approval ultimately was, I should say. Sections 5 and 6 then detail FENS's safety guidelines and requirements. First of all, with vegetation, it seems that they should be, where possible, low flammability species. And then you see throughout 5.2, FENS is concerned with vehicle access, firefighting, and that's where water tanks should be located, distances from couplings and hydrants, and that sort of thing. And at 6, fire zoning for management. So when I was speaking about banks, where the only access would be around the perimeter, this is effectively where that would be. You see in on page 10 the graphic, that figure 2. Section 7 deals with vehicle, first of all, section 7.1, vehicle or mobile equipment risk, and how that is proposed to be reduced. Section 7.2, electrical fire risk. 7.3, module fire risk. And then pausing at 7.4, again, we are told the grass on the site will be kept to an average maximum of 300 millimetres in winter and 200 millimetres in summer. The rest of section 7 then goes through similar discussions that the Greytown response saw. As you will see, there is no consideration of the specific Waipara location or the environment, no consideration of the vineyards surrounding the site, no consideration of the location of the township, particularly the township in relation to the site and the prevailing wind. If I can ask you to look at, finally to go down to the appendix to the REG report. This is a picture of the site with a FENS logo on the right-hand side and a table with tick boxes. What you can see from the ticks, what FENS have actually approved. I think we need to be very clear is that FENS have not approved this application as a whole. What they have approved is the tank and hydrant location, it's the first tick, tank and hydrant size, second tick, and the access points. That is the extent of FENS's approval. So 3 things from the REG report says. First, that there's no assessment of the exposed target in Waipara and how it differs to the exposed target in Greytown. Although it notes that there are some key features that are different, row heighting and the vegetation, that doesn't seem to have affected the conclusion in any way. And it recognises that potential toxic fumes from solar panel fires are possible, but it does not assess that risk in relation to the surrounding environment. And I'm going to say more about FENS's involvement in a moment. But before I do, there is one other issue I need to address regarding the REG report, and it's fundamental. When I was speaking, so on Wednesday, I indicated that there was a potential conflict issue that had just been brought to my attention that we needed time to investigate. It concerns REG, and we have been able to find some information over the weekend. You'll recall when I spoke earlier this morning about the history of this developer, I described the perfect overlap between the directorship and the ownership of the applicant and the company that received a warning from the Commerce Commission. That same perfect overlap of ownership and directorship exists between the applicant and the renewable engineering group. It has exactly the same directors as the applicant company. It has exactly the same shareholders. We've provided the company's register extracts that confirm that. They're at page 36 in our second bundle. They also, for reference, have the same registered address. Says that, combined with the fact that the reg report, as you saw, does not identify an author, does not list the qualifications of whoever prepared it, is deeply troubling, and it calls into question whether you can place any weight at all on the reg document. I say says you cannot and you should not. It is not an independent or an expert report in any sense. I have got an eye on the time, sir, but if you're amenable to leave the break a little while, it would be helpful if I could finish the section on fire and then we can pause. That's it. Thank you. So there are serious issues with the REG report. Other serious issues arise from the Becker report, the CFA guidelines around the site design here. But the more fundamental point is that none of these documents have considered what the effect would be in Waipara if a fire did get into or start on this site, including the effect of toxic fumes. That is just something that none of the documents have done. I'm going to turn to address FENS's involvement, because I suspect, sirs, that you might be thinking that they are the solution to this. But in fact, FENS's involvement has been limited and it has been very specific. You'll recall we've just looked at the appendix to the REG report, where we saw FENS had signed off on 3 things: water tank and hydrant locations, tank volumes, and access roads. That is the extent of their approval. The key thing that is missing, the key element in all of this that we do not have, is the assessment of the environmental effects if there is a fire in the plant from anywhere. And that is not addressed by FENS. If I could ask you please to turn up our first bundle of documents at page 197. This is a response from FENS to the Waipara Valley Community Collective. It's a reply to an Official Information Act request that the collective made, and FENS's reply is dated 28th November last year. The request was made in October. You will see we asked for 3 things. First of all, correspondence, particularly between FENS and the applicant and or the council. Then at 2, halfway down the page, any assessment by FENS of the actual or potential environmental effects of the proposal in whatever form. And over the top of the next page, the 3rd thing we asked for was any fire risk assessment compiled, produced, approved, or reviewed by FENS in relation to the proposal. So pausing on point 2, FENS's response to the question of any assessment they had done of the actual or potential environmental effects of the proposal, FENS's answer is quite clear. We can confirm that Fire and Flood Agency has not carried out any assessments relating to environmental effects of the proposal, because these types of assessments are not part of our functions. Perfectly straightforward. And then on the top of page 3, in response to the 3rd part of my request, we are told that they've provided documents and they refer us to the appendix for the fire risk assessment for the proposed solar plant. So I'll ask you to look at that appendix so we can see what FENS did. Unfortunately, it's in our second bundle of documents rather than our first one. Apologies for that. So, but if you could look at our second bundle of documents, the email correspondence that was provided in response to the OIA begins at page 40. So that's sort of the start of the document, but it's also the end of the email chain because we always read from the bottom up. So if you could go down further to page 64, please. So you see on page 64, the email chain effectively begins with an email from the council to FENS, and it's basically telling them about the Waipara proposal and seeking feedback from FENS. We go up one page, we have a reply from Mr. Irvine at Fire and Emergency. Basically saying, yes, Fire and Emergency are interested in engaging with the applicant. Then there's a bit of back and forth just on the practicalities effectively until we get to a larger response from FENS on page 57. So if you go up to page 57. And here we say rather longer email from the applicant to FENS, to Mr. Irvine, explaining what they're doing with the Becker report in Greytown. And then you have a reply back from Mr. Irvine on the page 56 above that. And first of all, noting that the earlier they discussed, the better. And then the middle of the page, Mr. Irvine states, we are likely to require firefighting water and considerations for a solar farm of this size and use the guidance of the CFA as a starting point for emergency management operations and understanding local response and capability training. So that's the CFA guidelines that we've looked at. This is Fire and Emergency saying that is their starting point. Then we have some emails with fairly short exchanges, effectively asking for updates. And then if we go up to page 44, is the beginning of a longer reply from FENS, and this is the longest email we've seen in this chain. So you see, first of all, Mr. Irvine explains that he was able to drive past the site and identify access points. He then talks about what water tanks would want to be located near the access points and what size water tanks should be. And then at the bottom of page 44, he notes that the river/stream to the north of the property provides natural fire break and protection to neighbouring properties. And Waipara Flat Road provides a break to the south. Just pausing there, that must be a reference to the Wecker Creek, a stream on the northern side of the property. So as you will have seen from yourself from the site that the nature of the Wecker Creek differs very much from in the southeastern half where it borders the site, where it really is a braided river, it's a wide open space, to the Wecker Creek at the northern end of the site, northern half of the site, where it is enclosed by vegetation. Now, so as I can quite understand that the southeasterly environment of the Wecker Creek, the braided river environment, would provide a fire break. but that can't be said of the Weka Creek as it is at the northern end of the site where it is enclosed by vegetation. You will have seen that yourself, sir, but for reference, in bundle 2 at page 35, we've included a photograph of vegetation at the Weka Creek at 163 Mackenzie's Road. Going back to the email then, we see FEN supports zoning for the site and speaks of where gates should be. And we have a picture that we've already seen once of zones. We have changes identified as to tank locations and access points. And then if you go down past the images, you see that there's a subheading vegetation screening. Mr. Irvine at the top of page 51, at the bottom of page 50, sorry, and then at the top of 51, at the bottom of page 50 refers the applicant to low flammability plants and recommends against the use of macrocarpus and native grasses. And then the last 2 points that Mr. Irvine addresses concern evacuation procedures and fire extinguishers. That's what we have in that email, primarily our input from fire and emergency around water tank and access points, along with some commentary on plant species and firefighting provisions such as extinguishers and evacuation plans. You have to go back up again, I'm afraid, to get to the next email in the chain. So back up to page 43. And this is the reply from the applicant, Mr. Irvine. Yes, effectively, we'll make those changes that are recommended. And then we have some more exchanges around those proposals, around those amendments. And at page 40, some additional comments from Mr. Irvine regarding access points in particular and water tanks. And the chain ends on page 40 with an email from the applicant to fire and emergency saying, yes, they'll number the gates as FENS have recommended, and asking, can we consider this email from you to be your approval? Now, I don't have a reply to that in the chain. I don't know if that's a result of the time at which the information request was made and what fell within its scope. But what we do know from the appendices that we saw in the REG report is what FENS ultimately approved was the access points, the tank locations and hydrant locations, and the size of the water tanks. So those are the extent of the emails that were provided in response to our Information Act request. 2 other documents only were provided with that. They were the applicant's AEE, so that had obviously been provided to fire and emergency, and they were the CFA guidelines that we saw the summary of when we looked at the Becker report. So the response of information to the Information Act request was these emails, the applicant's AEE, and the CFA documents. Now, you may be thinking, sirs, as I was, in fact, when I read this correspondence, that it doesn't seem to include the risk assessment that Fire and Emergency referred to in their reply on the Official Information Act request. You recall they said the fire risk assessment is located in the appendix. So we asked for clarification on that point. That's, if I could ask you to look up bundle 2, page 66. So we're in the same bundle. Start to page 66. Bottom of page 66, it was me emailing on behalf of the collective. I asked, please, can you clarify one thing? In your reply, you say FENS's fire risk assessment is included in the appendix of documents. However, I've not been able to find any document in the appendix that is a fire assessment. Could you check whether something is missing, or is the fire risk assessment, are you referring to the emails? And the reply from the information request team at Fire and Emergency is above. I can confirm that all information relating to Fire and Emergency's fire risk assessment is included in the appendix. No specific document was produced. Our assessment and advice was communicated via email to Farnell Solar Farm Limited. So those emails are the extent of it. It is notable, sirs, that although Fire and Emergency explains in those emails that the CFA guidelines are its starting point, there are key differences in this proposal with those guidelines that it doesn't seem to have identified. One final point on fire is, as we've seen from the Becker report and as you see from what FENS looked at, FENS's policy in dealing with a fire on a solar plant is containment. They do not try to put it out. They rely on containment. And the tracks around the site are to provide fire breaks so that containment can be possible. But as we know very well in Waipara, containment doesn't always work. In our second bundle at pages 70 to 76 and at pages 133 to 135, we've included articles about some of the fires that have occurred in and around Waipara in recent years. I'm going to ask you just to look at one of them, please. In the second bundle at page 70, so it's only a few pages down from where we are. This is an article on RNZ about a fire that occurred very near the site in Waipara in September 2024. You see at the bottom of the first page of the article, describes fire had been burning since Thursday. It was hoped that Fire and Emergency would be able to get it out, put out by the weekend, but strong winds saw the fire break its containment line and it moved from 40 hectares in size to 85 hectares in size. Fires can jump containment lines. Fires can be uncontrollable. We see examples of that frequently in Waipara. The effects analysis in this case cannot end at the assumption that a fire on the site will be contained. It must also consider what happens if it's not contained. Recall the Becker report noted that residential fires can result in toxic fumes. The problem is, if a fire gets into this site, we're not talking about a single house. And if a house catches fire, FENS attempt to put it out. That would not be the case here. So there's no one, not Becker, not the Renewable Engineering Group, not Fire and Emergency, not Miss Kirby, no one has done an assessment of what the environmental effects would be if a fire got into or started on a solar plant at 380 Waipara Flat Road. That alone is fatal to this application. As Ms. Labas tells you in her opening submissions, relying on Court of Appeal authority, the burden of proof is on the applicant. Finally, the last point, of course, is that no amount of mitigation can solve the adverse effects of fire risk that this proposal creates. Those risks arise, yes, in part from poor design, but more fundamentally, they arise from the site location and what surrounds it. Close proximity to houses and close proximity to the Waipara Township on the downwind side, township including a school, not to mention close proximity on the downwind side to State Highway 1. Bordered by vineyards on the downwind side, which are full of vegetation and trellises. They provide both fuel for fire, and vineyard trellising structures are notoriously difficult to firefight in because of the trellises and the access limitations. A site that is not flat, but includes, again, predominantly on the downwind side, steep terrace scarps, steep terrace scarps that will be loaded with vegetation, that is loaded with fuel for a fire. A site that is accessible only by State Highway 7 and not at all accessible on the downwind side. In a microclimate region that is known for its hot, high summer winds and dry conditions where wildfires of significant size routinely occur. You have heard a lot, sirs, from submitters about just how fast fire can spread in this area. I believe it was Ms. Antill who said, if you haven't lived in Waipara, you just don't understand. There is no mitigation, no remedy that can fix this problem. Sirs, that brings me to the end of my submissions on fire. I have gone way over our break time, but I think that's probably a sensible point.
Okay. Yep, thank you. You'll break until about 10 past 11, sorry. Thank you.
Barry, there are some issues of credibility in relation to his evidence. We have provided, and I don't think you need to go to it, but I'll give you the reference in bundle 2, pages 78 and 80, some of the sales material from when this farm was on the market. You will see it described there as a multi-purpose farm, equally suited to early prime land production, hogget finishing and cropping. And you heard from Mr. Harris, who has farmed in Waipara all his life, that he considers it a very sweet farm. Those were his words. Turning to noise next. Fundamental problem with the applicant evidence on noise effects is that it considers noise levels at dwellings. But as you have heard, many residents work and play on their properties at locations that are far closer to where the panels would be than their homes. Now, low noise limits at those locations are not set by the district plan. When you are considering permitted activities, you can only take into account hypothetical permitted activities that are a realistic possibility and not fanciful. I've already spoken on that in the context of screening, planting and shelter belts. The authority for that, one of the authorities for that is Guthrie and Queenstown Lakes District Council. The reference is in my speaking note. I say in this case, there is no hypothetical activity that is more than fanciful that will create the same type and unit duration of noise as this application and not itself require consent. That means, as I says, you should and you can consider noise impacts as they really are at all aspects of the site where they have an impact on residents and workers. That is both the construction period and the period of operation. And of course, it is not only the volume of noise, but the type of noise and its incompatibility with a rural environment. You have heard many submitters address you on that. In respect of glint and glare, I'll start with acknowledging that the expert reports address glare at a technical level, but I do think, sirs, that it's important to remember what this effect actually is in practice. If I could ask you to look, please, in our bundle 1 at page 366. think this should be in the forefront of your minds when considering glint and glare. This is a picture of glare from solar panels on Mackenzie's Road. I have two further shortish points at least about the glint and glare expert reports. And the first is that both the applicant's expert report and the council's peer review use the same Forge Solar modelling tool. The problem is that modelling tool is a black box. We don't know what assumptions have gone into it. As any scientist will tell you, the validity of a model is only as good as the assumptions that it is built on. We simply don't know, for example, whether it takes into account glint and glare when the panels are in different weather conditions. For example, when there's dew or frost on them early in the morning on a clear sunny day. It might be that those things are in part of the model. Question is, we just don't know. And both of these questions, I should say, might be things you would wish to explore with the glint and glare experts, and they may have a straightforward answer. If I could ask you just to look, turn up the applicant's glint and glare report, its initial report, please. That's included with the initial application documents. The first part I'd ask you to look at it, and this is a short point with this document, is at section 1.2, so it's on page 8 of the document. So under 1.2, the report identifies that the United States Federal Aviation Administration Authority defines glint and glare as glint being a momentary flash of bright light, and glare being a continuous source of excessive brightness relative to ambient lighting. So there is a difference, and they have different distinctions that's set out at the beginning of the report. What is notable is that while both expert reports are called glint and glare reports, what you will see in a moment when we come on to look at their data and conclusions, those data and conclusions only address glare. The report starts by separating out glint and glare. The actual analysis and conclusions only addresses you on glare. Where the word glint appears in these documents, it is always in conjunction with glare. It is always glint and glare as a phrase. There is no separate consideration, as far as I can see, of glint impacts. If you look down in this document, if you go down as far as 3.4.1, this is 3.4 is the section on results. See 3.1, 4.1, at this stage it was 0 rest angle results. The results are what glare there is. So hours of cumulative green glare, and then glare received for each day across the year. 14 minutes of green glare, no more than 7 minutes of yellow glare. Most glare occurring in the early mornings or late evenings. Now again, this may be a question that the experts can address straightforwardly, but it is an unknown. What has happened to glint impacts? Recall, glint impacts were described as momentary flashes of brightness. When it comes to considering amenity values and the impact on residents and locals and drivers' amenity, flashes of glint, even if they are not continuous so as to account as glare, flashes of glint are still relevant as an adverse effect in how they affect people in the vicinity. Even brief flashes of brightness may also be a distraction. So it says I can't take that any further because, as I say, Forge Solar software is a black box to us, but it is, I say, a question, at least something outstanding that we do not know around glint. Spend a little longer addressing tourism. As you've heard, sirs, this was a major concern for many submitters. And that was including those who have and work in their own tourist business, have their own tourist business activities. You will recall Ms. Naish's evidence that several local tourism boards understood that they were unable to make a submission on the application because of conflict created by their connection to the council. You have heard how tourism in Waipara is promoted, that is, in display boards outside this building, on the website of the Alpine Pacific Touring Route, and in the work of the North Canterbury Wine Growers Association. And we have included extracts of those documents in our bundles. You've also heard from many professionals working in this field how incompatible the proposed activity would be with tourism activities in Waipara, and indeed with wine growing activities, because you've been told that wine tourism is an important part of the wine growing business model. And there are articles to that effect in our first bundle at pages 369 and 373. One document I would ask you to turn up now, please, is at page 158 in our first bundle. This is Hurunui District Council's Destination Management Plan. You see the logo Visit Hurunui in North Canterbury on the top left of the first page. And then at the top of the second page, the first sentence, the destination plan for Hurunui District was prepared by TRC Tourism for Hurunui District Council. At page 2, you have a foreword from our Mayor, Murray Black. And then I would ask you, sirs, to please go down to page 164 in this document. Page 164 sets out the strategic priorities in the district management plan, in the destination management plan. You'll note the very first priority, 1.1, build on the Alpine Pacific touring route as a journey experience to attract and service all modes of self-drive travellers. That is the #1 priority, building on the Alpine Pacific touring route. See also 2.1, develop experiences that enable visitors to engage with the natural assets and communities within the Hurunui. That is natural assets, not man-made assets. 3.2, this is under the heading Targeted Destination Marketing. Target self-drive travellers. Hurunui District Council, through its destination management plan, is actively seeking to attract self-drive tourists to use the Alpine Pacific touring route as its #1 strategic priority in the destination management plan. And then at 3.3, drive demand out of Christchurch. We heard from Ms. Naish how Waipara is an anchor point on the way to Hammer Springs. None of these priorities are consistent with this application. Indeed, this application is fundamentally incompatible with these priorities, and there is no amount of mitigation that can solve that. At best, at the very best, a 4-kilometre stretch of one of the most scenic parts of the touring route will be lost. And of course, as I've already said, even if screening reaches the proposed height, it will not screen the plant entirely. There would be those 4 access points, wide gates with no screening all the way along the route. Solar installation would be visible, and it would be entirely out of keeping with what is expected on a scenic route. As to concerns about flora and fauna, we largely covered this off last week, and you've heard our submissions primarily on the Matagauri clearance. The last point to note about that clearance of Matagari is that the vegetation was significant. That point is made quite clearly in Dr. Merck's written submission, is submitter 142. Second point is that regenerative planting rests on irrigation first and careful management, neither of which are assured here. And you have Mr. Priest's evidence on how challenging it will be. And of course, the wider and more fundamental problem is that regenerative planting will firstly introduce fuel load into the site and introduce fire risk, and it will encourage birds to the site and thereby increase the risk of bird strike. It is another example of fixing one problem only to create others. So what I now propose to do is turn back to the legal framework and say where I say it takes us in light of the effects and the evidence that you have heard. So beginning with section 104D, because the activity is non-compliant, you may only grant consent if you are satisfied that one of the limbs of section 104D applies. Section 104D1A, the adverse effects of the activity on the environment will be minor. I don't think there's any serious dispute that the effects will be more than minor. Mr. Cocker's landscape assessment of temporary effects, for example, recognises there will be temporary effects that are more than minor. They are effects for this purpose. I think indeed it's recognised by the degree of mitigation that the applicant is suggesting is necessary, and the thrust of Ms. Labasse's opening submissions, that they acknowledge the effects on the environment will be more than minor. And as I say, I don't understand it to be seriously contested. The second limb of the section 104D test is subsection B. The application is for an activity that will not be contrary to the objectives and policies of the relevant plan. Ms. Annan, in her evidence, considers the application would not be consistent with those. And at the conclusion at section 5 of the joint witness statement, this is the point on which Ms. Annan and Mr. Cocker differ. And we're told in section 5 of the joint witness statement that Ms. Annan's position is that residual landscape and visual effects exceed a level that can be considered acceptable in terms of maintaining the landscape values and character anticipated by the district plan, and that Mr. Cocker's consistency conclusion does not sufficiently account for the local landscape values. And I have already addressed you, sirs, on why I say you would prefer Ms. Annan's evidence over that of Mr. Cocker's. What I propose to do now is go briefly through the key policies and objectives of the district plan, which we say this application is contrary to. In your hands as to whether you wish to turn it up as we go through this. Objective 3.1 is the first objective. The character and amenity values of rural areas of the district are maintained while providing for a variety of activities, including those associated with primary production. This application would not maintain the character and amenity values of the rural area. You have heard the evidence as to how it would fundamentally change those and how it would fundamentally remove the amenity values for those who enjoy the Waipara Valley rural area. Policy 3.5 of the Hurunui District Council District Plan, to enable a variety of activities to occur within rural areas while managing adverse effects on character and amenity values by seeking that the scale and siting of the development, number one, maintains a dominance of open space and plantings over buildings, especially when viewed from public places such as roads. The application would at best replace the open space that currently exists on 380 Waipara Flat Road with buildings in the form of panels. It would remove the open space for 3.5 kilometres along State Highway 7, at best replacing it with screening and intermittent views of buildings. That is contrary to 3.5.1. Policy 3.5.2. This is seeking that the scale and siting of development maintains privacy and rural outlook for residential activities. I think there's no particular concern as to privacy in this case, but the rural outlook is fundamental. And you have heard from numerous submitters on that. Policy 3.5.3, citing the scale and siting of a development achieves an appropriate level of compatibility with existing development within the area. In this case, the application is inconsistent with the existing activities in Waipara, that is, existing grape growing activities, wine growing activities, and tourism activities. The scale and siting is appropriate to the location, including recognising the need for activities reliant on a natural resource to be located where the resource is available. This is 3.5.7. The application is not appropriate to the location, given the existing activities, and given most particularly the fire risk that it would pose to nearby properties and the Waipara township. And that is the risk not just from fire spreading to those properties and townships, but also the risk of toxic fumes from a fire reaching those properties and locations. Policy 3.1.6. To manage potential conflict between incompatible activities in the rural environment so that residential and other sensitive activities are located away from incompatible rural and rural-based industrial activities and other activities that have a functional or locational need to locate in the rural zone. The application creates a conflict between incompatible activities by placing a rural-based industrial activity in close proximity to residential activities. Objective 7.1. The development, operation, maintenance and upgrading of new and existing renewable energy generation activities is provided for while ensuring that conflicts between these activities and sensitive environments are managed. The application creates conflict between renewable energy generation activity and the sensitive environment of the region. Objective 7.2. Energy generation, supply and use, 7.2 concerns non-renewable energy generation, that's not relevant here. Policy 13.2, protect areas identified as having significant Indigenous biodiversity value by avoiding, remedying or mitigating adverse effects using appropriate mechanisms, including where identified through a resource consent process. The application involves the loss of significant Indigenous vegetation in the form of Matagara clearance. And finally, objective 15.1, subdivision, use and development of land is enabled while avoiding or mitigating the adverse effects of natural hazards. This application increases the adverse effects of natural hazards by increasing the adverse effects should a wildfire get in the vicinity of the site, reach the site and affect the Waipara township and State Highway 7. So as I said, it's quite straightforward that this application is contrary to the provisions, objectives and policies of the district plan. Neither limb of the section 104D threshold test is met, and you may not grant consent. Consent, therefore, on the basis of section 104D must be declined. Now, as I explained at the outset, we say we are in the territory of 104D because this is a non-complying activity. If you're not with me on that, and section 104 applies instead, my submission is that the extent and scale of the adverse effects that you've heard are such that consent should be declined, and that is particularly, but not limited to, fire and tourism effects. For those effects, the only possible remedy or mitigation is the selection of a more appropriate site. You cannot move the location of the site from the Alpine Pacific touring route. You cannot move the location of the site so that the Waipara township is not on the downwind side of it and in such close proximity. Those two factors alone require the consent application to be declined. Under section 104 and under the National Policy Statement on Renewable Energy Generation, Policy F2, section 6 RMA matters of national importance are engaged here. The protection of areas of significant indigenous vegetation, that's the Matagari, and the management of significant risks from natural hazards, that's the wildfire risk. I say that's a natural hazard there because we're not there talking about the fire risk of what we're talking about, the fire risk starting in the site and developing into a fire that travels from the site, and also the risk of a wildfire starting, say a grass fire starting somewhere and traveling into the site, and the risk of that natural hazard being greatly increased by the presence of 180 hectares worth of solar panels. Now, I addressed you at the outset today on the fact that the district plan is consistent with the National Policy Statement on Renewable Energy Generation. That being the case, there's no requirement for you to look beyond the district plan and to consider this directly under the policy statement. But it is reassuring that if you do look directly and assess this application directly against the policy statement, you reach the same result, that it should be declined. So, like the district plan, the policy statement requires consideration of safety and of the well-being of communities. Both those requirements require you to decline consent because the application will put safety and the well-being of our communities at risk. Like the district plan, the National Policy Statement requires you to consider whether mitigation or offsetting is possible. Particularly for the fire risk, mitigation and offsetting is not possible. You cannot offset for such a risk. Like the district plan, policy statement recognises that sometimes adverse effects cannot be avoided, remedied or mitigated. It does not require consent to be granted in all cases. Whether you approach this thus under the district plan or directly look at it under the policy statement, the fundamental problems of this application, particularly as to its impact on the safety of Waipara residents and their well-being, both physical, economic and social, both permit and require consent to be declined. Now, I've spoken as we've gone along, considering different adverse effects, but there are numerous effects here which are simply not capable of being avoided, remedied or mitigated, fire and tourism being the most stark of those. So the answer that perhaps one may usually expect in respect of a large development like this, that it will probably come down to what mitigation is appropriate, that is not the answer here. There are simply too many fundamental problems. They are fundamental problems because of the site that has been chosen. Nothing illustrates that more strongly than the fact that mitigation proposed to address one problem only creates another problem. We have seen this time and time again. Regenerative planting whether that is to mitigate for the loss of significant indigenous vegetation clearance or to provide softening effects. Mitigation, the regenerative planting unwittingly increases the fuel load across the site, attracts birds, increasing the risk of bird strike. Screening the entire of the perimeter along State Highway 7 reduces the risk of glinting glare, but it eliminates the expansive view of the Waipara Valley along the touring route. Lowering the height of the panels, as Mr. Andrews told you, to reduce the visual impact from State Highway 7. Lowering the height necessitated extending the plant onto the lower terraces, increasing the adverse effects on Mackenzie's Road properties. It also resulted in the rows being put closer together, removing the ability for farm vehicles to drill and sow between rows, and thus reducing the ability for the farm to continue to act as a farm. In the absence of drilling and top sowing, the farming on this activities on the site are substantially reduced. The other effect, of course, of decreasing the distance between rows is that it increases the fire risk. Mitigation cannot solve these problems, and nor can the conditions solve the problems with this application. In several key places, the proposed condition is to leave the problem to be addressed in management plans. That is not appropriate where there is no certainty that the condition is actually achievable. Consider, for example, dust management. Proposal is for a dust management plan. If it turns out that the dust management plan can't achieve dust control, particularly on dry and windy days in the Waipara climate, the only option will be to stop construction until the weather changes. That delays construction, extending the adverse effects period of construction. If you don't have the detail to assess the viability of the proposed management of dust, you cannot assess how long the construction period is really likely to be. You will recall Ms. Alcarmel's evidence as to how the required grass height condition could be met. Her answer was to suggest that the applicant may be required to provide photographic evidence. But of course, the photographic evidence only shows whether the condition has been met. It doesn't address how, and it doesn't address what happens if the grass isn't as short as the condition requires it to be. What if the sheep do not eat the grass down low enough? You may recall Mr. Lee, who's submitter number 115 in his written submission. He addressed how in his experience of sheep farming, particularly in Waipara, sheep do not eat the long dry summer grass, tag he refers to. What happens if that turns out to be the case? Once the plant has been built and the panels have been put in place, the risk has been created and it cannot be removed without removing the panels. If the proposed risk mitigation, keeping sheep to keep the grass down, fails, the entire risk remains there unmitigated. Cannot impose a condition on grass height unless you have realistic evidence to conclude that it is achievable. Further on that point, sirs, and this is a matter of law, and I suspect it may be one that's going to need to be resolved up through the higher courts because it relates to a change in legislation that's incoming. The Resource Management Consenting and Other System Changes Amendment Act of last year would introduce a new subsection into the RMA, subsection 104(2)(EA). That will provide that when considering a consent application, decision makers can take into account whether an applicant has any enforcement orders against them, among other things. So conditions you impose now will engage the new section 104 subsection 2(EA). Meaning if an enforcement order has to be taken against this applicant in relation to a condition you set, that will have lasting consequences in how the applicant's future consent applications may be addressed. In those circumstances, it would be ultra vires for you to impose a condition without knowing, without being confident that it is reasonably achievable. Otherwise, you are setting up a hurdle for the applicant that will have lasting consequences that it has no ability to actually achieve. That cannot be lawful as a matter of, that cannot be right as a matter of law. Finally, on conditions, and I only address it specifically because Ms. Labas did in her opening legal submissions, and that is to whether you should consider imposing a bond in this case if you are minded to grant consent. Just 2 short points on this. When the application was initially made, the applicant was working in partnership with an offshore investment fund called Aquila Capital. That joint venture has now ended, and Aquila are no longer involved in financing this application. The press statement to that effect is included in our documents. That leaves an unknown question as to what the applicant's financial status is. And I referred you earlier to the developer's history as being an area of concern in this region. The reference for the press article addressing the business history is at bundle 1, page 432. I just have a few final concluding remarks. So, as you've heard over the last week, the problems with this application are myriad. It may be that an instinctive reaction to the problems is to give the applicant more time to provide further evidence. That is not the right course here. You will recall that by your 4th minute, you reluctantly agreed to an extension of the hearing date, but in doing so, you made it clear that no further extension would be entertained. The applicant cannot be allowed to present so poor a case that it succeeds in achieving by the back door what you have already refused it by the front door. Moreover, we must ask, what could more time realistically achieve? The applicant has already had over 2 years to prepare its case, and no amount of additional time or information or evidence can solve the fundamental problem with the application, because no amount of further information can change the site location and the surrounding environment. If lack of information is your concern, the answer is provided by section 104, subsection 6, decline the consent on that basis. I hope it has become clear over the course of the last week that this is not a situation where local residents and submitters are concerned about the idea of a new proposal, but can be reassured by understanding its detail. It is the opposite case. Close examination of the details of this application only heighten the concerns raised. Waipara Valley Community Collective has not instructed legal counsel or experts. We are a grassroots, entirely volunteer group, and every dollar we have is raised through the hard work of our volunteers and the generosity of our community. We have shared with you one example of that, and that's our Waipara Valley calendar. But submitters should not need to spend tens, if not hundreds of thousands of dollars on experts for an application like this to be declined. We should be able to rely on the council, and now on you, to examine an application critically and carefully of your own accord, which in this case can only lead to one result. Also should not lose sight of the breadth of opposition to this proposal. It includes over 100 submitters, including the Waipara District Residents Association, the North Canterbury Wine Growers Association, numerous local businesses and individuals. It includes those who would be most affected with the proposal on their doorstep, and it includes those concerned about it from further afield, even so far afield as the UK. Consider the amount of evidence that you have heard from people who have done so much work enhancing biodiversity in Waipara, people who genuinely care about our planet and our environment. They are not anti-solar. It is because of the care they have for our environment that they are concerned about this proposal. Concerns that are amply borne out by the evidence. Compare that to those who say that this is a good site for the proposal. That is primarily Mr. Andrews and one submitter you heard from last week. When explaining why this is a good site proposal, it is telling they answer only with the ways it is good for the applicant and ignore entirely whether it is good or not for the community. Finally, when I started preparing these submissions, the phrase that kept coming into my mind was the dog that didn't bark. It's a phrase that comes from an old Sherlock Holmes story, and it refers to the idea that sometimes the most significant bit of evidence is the absence of something. That is exactly the case here. The failure of the applicant to address effects on tourism, to address effects on fire, to address water, to address the cultural and associative values the community has within this environment. The list goes on. It is not one dog that didn't bark, sirs. It's a whole pack of them. I'll end there, but of course, any questions I'm very happy to take.
Thank you. Thank you. It's very comprehensive. You've covered a lot of ground. I don't have a lot of questions because you've actually got a lot in there, and it isn't that I haven't listened to it or heard it or read it. It's just that you've covered a lot of the things that I had questions about. So let's talk about State Highway 7, which we've driven on several occasions, both directions. And you described the view from State Highway 7 as being relatively open. But it's not, I mean, there's a whole lot of shelter belts all the way down that road. There are certainly pockets where you get a little vista to the hills. But in general sense, I wouldn't describe it as open, would you?
Yes, that's not my memory or my experience of that drive. My experience of that drive, particularly, I think you get the impact most when you're coming towards Waipara from the Waikari end, because you go through the confined part of the Weka Pass, you come up a slight rise, and then you have the open view across to Mount Cass. You can see shelter belts, but that wide expanse that hits you when we come out of the Weka Pass, that's the view that I personally mostly associate with that road. And then, so you come out of the pass, it hits you, and then yes, as you travel along, you lose it for patches, there's the screening belts, but then you see it again. So you get the impact first, and then it keeps coming back.
So I know exactly what you talk about, that as you come around the corner, I think there's a little pull-in bay or a metal place there that you can stop at, and then the road comes down and drops. So that view won't be to Mount Cass, won't be screened, will it? Because the proposed screening will be much lower. So Mount Cass will still remain as the dominant view there.
You'll see screening belts, because there'll be screening belts all around the perimeter. Yes, you'll still see Mount Cass above them, but what you won't then get, what happens at the moment is you get that view, and then as you drive along there, it draws your attention. You'll get the initial view, but then you won't be able to look further. You won't be able to appreciate it as you travel. So it'll be, rather than travel along there for 4 minutes or so, 3.5, 4 minutes, haven't timed how much of the time the shelter belts are there for, but pretty much it's there the whole time and you keep getting glimpses of it. Instead, you'll get that one glimpse and then you won't get it at all, apart from where the screening belts open and you'll see the solar plant through the gates.
Okay, so those shelter belts that are there at the moment, and they, we had quite a close look at them. I would describe them as probably 10 to 12 metres in height as you come along. And so the proposal was to reduce those down to 5 metres in height. Wouldn't that open views to Mount Cass?
I mean, yes, if they're shorter, then in those places you will see some of Mount Cass still in the background. But I think it's a bit apples and pears, because you're talking about more of a partial view. You won't get the vineyards in the foreground, you won't get the sense of, I'd say, of the valley, but you will see the top of Mount Cass in the background, whereas at the moment you get the full expanse and then a brief bit where you don't get it, and then it again.
So can you see foregrounds in the valley behind the shelter belts at the moment? I'm trying to think, because if you look through those shelter belts in those gaps, there's no view to a vineyard to the left of the road. There's definitely one on the right hand side of the road, which won't change.
Yeah, you see.
But you see across the village, you don't see any vineyards.
Yeah, you look across and you can see. Can't see the creek, but you can see where it is because you see the vegetation surrounding it, and you see the top terrace of Mackenzie's Road.
Okay.
I know with certainty because you see my house.
Yeah.
But one thing I said that when the first thing you talk about on that drive, for me personally, is the view you get when you come out of the Waipara Pass. I should say actually that I drove along there just a few days ago in the evening in the other direction from Waipara, and the three Deans on the right, the view across to them with the light hitting them at that time of night was absolutely stunning. So, and that I think would be predominantly lost because of it's the slopes and the way the light changes on the slopes, and you'd only see the top of them above the shelter belt.
Again, there are any glimpses, aren't they?
Yeah,
I've sat down and tried to measure it. So there's over 1.5 kilometres trees actually on the boundary, and then there's 4 shelter belts crossing that property. That's the existing environment at the moment, and those trees are, as Mr. Bracey says, they'll be at least 12 metres high, if not bigger. So what you get, when we've driven it a number of times, are glimpses. But that's pretty much it.
I fundamentally disagree, and that's not how I view it at all. I think there's a distinction between the shelter belts that are on the roadside and the ones that traverse the property. The ones that go across the property at the moment, they don't block out the view. They're part of it. They're not, yes, you don't see what's behind them, but they sit in a rural landscape as what you would expect in a rural landscape. The ones that are on the road, right on the roadside, do block it out, but I think if it's over 1 kilometre, 1.5. So the majority of it isn't shelter belt, the majority is open. It's 3.5 kilometres, the whole thing.
Okay, so I mean, we're asking these questions because we're really trying to understand it. This is a critical effect. So we're trying to really, get to the bottom of it. So you said that shelter belts are expected in a rural environment.
Yeah. Okay,
so I heard your permitted baseline argument that perhaps a shelter belt around the entire property is not something that's usual, but a shelter belt along the length of State Highway 7 could be.
Not in this case, because if you have water to plant shelter belt for that entire length, surely it's not realistic to think that any farmer would do that as part of normal farming activities. Shelter belts are valuable because they provide shelter. The ones on that side of State Highway 7 aren't providing shelter for them from the prevailing wind. The prevailing wind is the northwesterly. They're providing shelter from the southwesterly, which we do occasionally get, and they provide good shelter, particularly actually, southwesterly rather than north and south. They provide shelter for stock. You do not need shelter for that all the way along that space. it's just not a realistic thing that would need to be done.
Okay. And so what's your feeling about houses along that? I mean, there's two housing lots now proposed there.
Yeah, I'm not on top of the details of those proposals. As I understand it, they're sitting within the current zoning, so it's 4 hectares, I think, per site. I think that's very in keeping with the Waipara area, because it's one house in a large space. It's fundamentally different to somewhere like Ravenswood, where you have urban development.
Okay. You also talked about, you said that a solar farm is not something you would expect to see on a touring route. What would you expect to see on a touring route?
Pretty views. That's a glib answer, but I would generally expect to see pretty scenery. What
about hydro dams?
I don't know. I don't think I've been on a scenic route past a hydro dam. It's not something I wouldn't.
Pass.
I haven't pass, no. I think, yes, I don't actually have a visual in my mind of what you're talking about. So yeah, I probably shouldn't say more because I'm not quite sure we're on the same page.
What about wind farms?
Wind farms, I think with wind farms, and probably to an extent with solar activity, it depends more on the scale. So 1 or 2 wind turbines in a given space, probably not something that is going to stand out dramatically, just as the odd frost fan doesn't stand out dramatically. Similarly, you might say a smallish area, a couple of hectares of solar plant panels wouldn't stand out. An entire wind farm that covered 180 hectares, not something I would expect to see.
Okay. And you're getting those all around the country?
It's site specific. I think that's the problem. You've got to look at the application before you. I don't know details of others all around the country. I don't know where they are. I don't know if they have similar effects. For this one, I can only look at the one before us.
I guess I'm just questioning you if it's not perceived as rural and not something that's expected in a rural area. And yet, that's the district plan does perceive it as being in a rural area, and that is where they're being developed. Even the airport one is in a rural area.
Well, I don't think I'd characterise the airport as being in a rural area. I know it was a field before the panels went on, but it's right next to an industrial plant, effectively.
It's zoned rural.
Yeah, it's zoned rural, but whether that accords with someone's perception of what a rural area or not is a difference. But of course, the district plan doesn't say you can do these anywhere in a rural area. It says we know that they have to be in a rural area. That accords with policy direction, but we need to manage where they go carefully so that the adverse effects are managed.
So you'd agree that they need to be in rural areas? You just said that.
Oh no, I said the district plan recognises that. Do I personally think you need to put large-scale solar plants in rural areas? That's a broader question. I'm not sure I do, but I should say that in that view, I can only speak for myself because that goes beyond what I can say on behalf of the collective. And we do actually within our group have quite a range of different views as to where solar is appropriate generally and the bounds within that.
Can I just ask you about that reference to opposition to solar farms? Does that comes out of where the states?
Yes, research out of the states, but it considered trends in opposition in the US and in the UK.
Was that just trends in opposition to solar farms, or was it trends in opposition to?
It was solar farms.
Just solar
farms. It wasn't mostly about the opposition increasing. That was the starting point. What it went on to address was some of that opposition coming from what you might expect as sort of being typically anti-climate change perspective, but also increasingly opposition coming from people who pro-sustainable environmental management and viewing the concerns around solar plants from a sustainability and environmental perspective. So that's slightly off topic from where we are today.
Is it, do you think it's any different sort of in the opposition to say, let's say, density increases in urban areas, which we're currently seeing in this country? We've seen that in Auckland over recent times. You're seeing it in Christchurch at the moment. The opposition to that type of development. Is it any different to that extent? I know it's a big question, but
yeah,
it's
it is different because it's apples and pears again. There are, and it's not something that I'm very familiar with, so I'm entirely off cuff. I'm imagining what that opposition is. Part of it, I suspect, is change of area, but also the impact it has on facilities, schools, communities, travel, transport, all of those sorts of things. Those aren't factors that we're looking at here.
well,
The factors here are quite different.
let's say wind farms. We had the same issue replied in New Zealand during the 2000s. Was when there was a serious opposition to wind farms establishing around the country, particularly in the Manawatu. So here, Mount Cass, Smith is closing Mount Cass, Meridian one, which was further up, same sort of issues. Yeah.
No, entirely different. Not least because of the fire risk in this case. You can't get away from the fact.
But visually.
Purely visually. Similar considerations, but different scales. So I think, and again, not speaking on behalf of the group, I think wind farms are one where there's a much more diversity of opinion. Some people find them actively attractive. Some people find them unattractive. Some people, they fade into the background. I don't think there's such diversity when it comes to an industrial scale solar plant. I don't think you've got people saying this is actively attractive. Mr. Young, who described it about as attractive as tarmac. Yeah, there might be, but even if I think it's if there are fewer with respect to wind farms.
Yeah, it's interesting. I mean, you probably haven't heard of the Power Pylon Appreciation Society, which is pretty active. You know,
I think I have. Do they have a Twitter account?
Yeah. You know, and Woodville's. I mean, I think the wind farms. You're right. The wind farms are interesting. The ones on the Manawatu. I don't know if you've ever seen them, but I think there's 170 odd there now, turbines. And
different sorts,
all the different sorts, different types, yeah, cluster. And the logo for Woodville now is a wind turbine.
I'm not familiar with them, so. But I think one thing, just I've been sitting here visualizing a wind farm. When I do that, I typically envisage it in the distance, or it's from some distance away, so along the ridge on Mount Cass. I think that proximity is a factor as well. We're not talking about viewing it from a distance here. We're talking about it right on the doorstep.
Well, you did say that you would see it from Mount Cass.
Yeah.
Which, ironically, you'd be under a wind farm when you did see it.
Yeah. Yeah. So that's to demonstrate the enclosed nature of the valley. I think that's the factor that has to be taken into account. So at the moment, when you go along that road, yeah, we're focusing, I think, sort of dividing out, just look at that view, then look at that view and consider it separately. Of course, what you're really doing, really experiencing the landscape is a whole, and going on there, you're getting that, you very much get the enclosed nature of the Waipara Valley with Mount Brown, the Three Deans coming around to Mount Cass, only really open towards the Christchurch side. It would be a big impact in a comparatively small space.
Okay, let's work on the basis that the vegetation screening is successful and does what it is meant to do and completely screens the solar farm from State Highway 7, with the exception of the gate, so I accept that. Where else would a tourist see the solar farm?
We've heard evidence that there are a variety of properties on Mackenzie's Road, which intended to, and to some extent we have very limited solar tourist activities on our property because we've only doing the things that don't require significant financial investment up front. But from all those tourist activities there, if you have I think Miss Naish referred to seeing it from the Hurunui Trail, the Vineyard Trail, that goes up on the back of Greystone, and we do get tourists attracted to the wind farm from there.
That's quite some way away, and I think it was only a small part of that trail. When that trail started in the village, we wouldn't see it, and then traverses along, you know, the lowland and up north away from the proposal. So you actually wouldn't see it from that trail until you were only at a small point above Greystone. Is that right?
Yeah, as far as I know,
yeah. And I just wanted to confirm, you said that lowering the panels, the option to lower the panels to reduce visibility resulted in the proposal getting bigger, but it hasn't got bigger, has it?
No, not getting bigger. And Mr. Andrews' evidence, if I'm recalling it correctly, was that capacity output to keep the capacity that they desire from the plant, because when they were the higher height, there were effectively 2 levels of panels. When they took away the top level of panels to maintain the output, they also put panels on the lower terrace, and they put the rows closer together.
But they were on the lower terrace right at the beginning of the first application.
They extended the area on the lower terrace. Right. This was Mr. Andrews when he gave direct evidence last week. I think it's the area, the lower terrace on the sort of southern eastern end rather than the lower terrace on the north.
Are you aware of any solar farms that have been declined consent in New Zealand because of fire?
No. I don't know if there are any or aren't any.
I think that covers what I have.
I've just got another question around, so we've had a number of submitters who've come along and said, well, it's the scale of this solar farm which is the problem, and if you reduce the scale and shoved it in the northern part, sorry Mr. Young, shoved it in the northern part of the site, we'd be okay with that. Does the collective have a view on that?
It's not a scenario we've considered. It just hasn't been something we've considered. I think because that would be so different to what's being proposed. Our discussions have been around this proposal, not some very, very different proposal.
Just going back to the screening, I think the condition is the screening to be kept to 5 meters. Does it need to be 5 meters along the state highway? Be 3 meters.
It's probably a question for
I'm talking about
visually. Okay.
Sorry, it's not.
Perhaps an easy way of asking there's a trade-off, isn't there, between perhaps seeing the tops of the panels at some point, but having an open view.
Yeah.
So, you know, a broader view. What would be the difference to ensure that it's absolutely screened from view, or to retain some level of openness?
Oh, it's a really tricky one because if you see some of it, even if you don't see very much of it, it affects your impression of the area as a whole. It stops being, oh look, we're in a beautiful vineyard country, and it's, oh, we're in an area full of solar panels. And that's true even if you're only seeing a bit of them. So it's a very hard trade-off. I don't know.
I'm not going to work through the. Thank you.
Thank you.
Yeah, thank you very much. I realise there's a lot of time gone into that, so well done, thank you. Okay. So for council, there's Mr. Trevethan on. Who you want to start? We'll go straight to council now.
Yes, I'm just trying to talk to Jeremy and get him done. Get it done. I don't think there's too many questions. Ben, will you be able to hear us at the moment? Jeremy, can you hear us?
Yes.
Just
He does say before he was tuned in, so that's
would it be easy if we just broke for lunch now? We'll just break for lunch. I think that'll be easier. Then you've got them online, and you're all together. So we've got a few questions for Jeremy, and but yeah, that's the
We had a couple of questions for her.
yeah. Yeah, so if you can get them both online, we'll deal with them first and then come to Benson. Okay, we'll break to 1.
You take opinions from the floor.
Thanks, Julia. And I'm good at will do. We come back home, right?
Okay, resume this afternoon. So we've now got council, and I think we want to start with Mr. Trevethan and Mr. Van der Velden. I'm assuming they don't have statements to read, am I right? Okay, Mr. Trevethan on there. So afternoon, Mr. Trevethan, have you got a statement you want to read, or can we go straight to questions?
No, I don't have a statement. I do have a couple of notes that I've sort of taken along the way of matters that there were questions on, but they may be the same as the questions you have noted, so happy either way.
Let's deal with the matters that you've got, and we'll see if those answer our questions.
Yeah. So firstly, on construction noise, you had some questions from Mr. Ibbotson about the character of the piling noise, etc. I guess just confirming that I agree with the answers he gave you there. That particular form of piling, sort of a dull metal on metal sound, and you can hear 2 or 3 impacts a second as the pile was driven into the ground. And I understood that perhaps the idea had come up that the construction noise management provisions could appear as a section of some other overall construction management plan, and just confirming that from my perspective there'd be no particular issues with that if it was more efficient. And then my other notes were just on condition 102 and 103. Condition 102 is the reverse sensitivity sort of noise condition.
Yep.
All right, I have to have it. Thanks.
Yep, okay.
So there's condition 101, which is the noise limit, which applies generally into existing dwellings, and then condition 102. Yeah, I guess in my evidence, I noted that new dwellings I had understood couldn't be built without a resource consent within 80 metres of the state highway, and sort of concluded that possible reverse sensitivity was probably therefore a non-issue, as the solar farm noise levels are potentially only elevated within 80 metres of the state highway. So condition 102 sort of therefore seems to relate to a scenario where someone does obtain a resource consent to build a dwelling close to the state highway, and then whatever measures that are put in place through that consent process to mitigate the road traffic noise, prove to be inadequate for the solar farm noise, and the solar farm noise is prominent over the traffic noise to the extent that it creates a reverse sensitivity issue, which all seems relatively implausible to me. And then I'm not quite clear sort of what the presence of condition 102 in those circumstances, how that would assist. I guess it would give a line in the sand of what the solar farm was allowed to be emitting in that area. But yeah, it all seems reasonably complicated for an unlikely scenario, as far as I could understand.
Okay, so you, let's just touch on that one. So you don't favour that. As a result of the hearing going on, I'm not sure whether you've been made aware, but there's actually a subdivision consent for land adjoining the site to the north. Now, obviously the 80 metre setback still applies, but that doesn't mean that there couldn't be a dwelling in proximity to the boundary. Have you got anything you can enlighten us on that one?
Yes, yeah, no, I did happen to be listening in during that discussion. And Mr. Ibbotson's noise contour plot shows the 45, which is really the key noise contour, doesn't travel off the solar farm site to the north in that area. So that means in terms of both compliance, I guess, should compliance be required at those dwellings with the regular noise limits, there wouldn't be an issue. And yes, it would be a high traffic noise area regardless. So in terms of effects, there wouldn't be a concern there.
So given that, does that sort of, given that one's in proximity versus across the road, which is what you're originally considering in terms of condition 102, does that sort of, I guess, does that mean that your view is that 102 is even less necessary?
The contour plot does show that across the road, with the assumed placement of the inverters, the contour does bulge out into private land there. So, there's a circle with, or a little arc that's maybe 40 or 50 meters from the road. So, I mean, theoretically, there would be room for a dwelling to be located in that area. I guess the probability of that, and as I said, the circumstances around it, which presumably would have something to do with getting a consent where it was demonstrated that the traffic noise was being adequately addressed. Yeah, it does make me wonder about the need for the condition.
So just to be clear, if the traffic noise is if there's a consent obtained within the 80 metres, or seeking a consent in 80 metres, and in order to address that, which the house was insulated to whatever level was insulated, would that also address any noise emitting from the solar farm?
Yes.
Just on construction effects, I have a couple of questions on that. I understand that the acoustic report is based on, I think it was 5 to 10 vehicle movements per day during construction. And I think the AEE suggests that it was going to be 6 vehicle movements per day. But then, yeah, and I think that's heavy vehicles. But we have heard some other concerns that that doesn't necessarily include smaller vehicles within the site, such as, you know, contractors' utes or vans, and I think we did run reports with NZTA where it suggests it could be as many as 90 or so vehicles on the site at any one time. Can you give me any comment on whether, you know, that level of vehicle activity during construction is likely to, you know, increase potential noise effects?
Yeah, I mean, that level of vehicle activity either way is relatively low, especially if distributed across, you know, the large site. In terms of the heavy versus light vehicles, it is the heavy vehicles which really do have much more potential to be heard off-site and have an effect. You know, it's, I guess, an order of magnitude thing just about. You know, you need 10 light vehicles to have a similar combined noise level to one heavy vehicle. So I think, yeah, either way, numbers of that magnitude in terms of a noise effect are not of concern.
Okay. And actually, was something I just thought of, which I did think about when I was reading this material earlier. I don't think there was anything in there about heavy vehicle reversing and squeakers or anything. Is that covered off anywhere? Can you recall?
Not that I recall. Yeah, I think, I mean, Mr. Ibbotson may be able to sort of speak with some more authority on this, but in terms of the types of heavy vehicle movements for this type of construction, they'll primarily be about deliveries and that sort of thing. And I think not a situation where reversing is a common sort of planned part of the manoeuvring of the vehicles on site. You know, it's not like a quarry or something where vehicles are reversing in an area to be loaded or to unload. So I don't imagine that will be a very common feature, even if the vehicles did feature beepers.
Okay, thank you. And then, again, in terms of construction, you know, I think the references or the conclusion is that although it can be managed under a noise and vibration plan, construction noise will be higher than current background noises during the period of construction. And so I'm just wondering whether there is anything about the duration of that being 2 years, whether you think that's a long period of time to withstand construction noise.
Yeah, I mean, construction projects generally are reasonably long term in most contexts, whether it's sort of civil, building a building type thing or an infrastructure project. So that particular time scale, is not very abnormal from that point of view. In terms of what will actually be experienced over that time, it really will be only a subset of that time where the construction is plainly audible offsite, and that's during the piling. And so, there will be some months where that activity goes on, but it will move across the site, so it will vary in level for a particular receiver as that happens. And then there'll be, many months where there's, installing the panels and that type of thing where, that work will generally probably not be audible at receiving locations.
Okay, so just, pick up on the point about piling going in. I mean, is there any value in including a requirement to stage that piling activity so that perhaps happens all in one area and then moves to another area, and then we think that'll happen naturally?
Yeah, to some extent, it's always a difficult one, the idea of, sort of getting involved with controlling something in that segmented sort of way, whether you actually end up having controlling the effect in a way which is preferred by receivers or sort of elongates the construction if they, end up restricted so they can't move through the work in the most efficient way possible. So yeah, it's probably difficult from my perspective to understand what the other constraints might be. But normally with a building project, for one reason or another, they're trying to move through the work as efficiently as possible, and that's the best case scenario from a noise point of view as well.
I think that's
but just on the same issue, is it, in your experience, likely that the noise will be, because it's a rural environment, it's going to be more apparent than, say, an urban environment in terms of that construction noise?
In some locations, that will certainly be the case. I suppose both types of environments, there can be a lot of variability, or as you see here, I suppose, with locations that are closer to the state highway, there is some significant other ambient noise. But then as you move to the east, it's a more typical rural environment. Urban environments, can be the same. We're a suburban sort of environment with, only small local roads. During the day, construction noise, can similarly represent a pretty large change compared to the status quo.
And what's your experience been with other solar farm developments in terms of noise? Construction noise, I mean, sorry.
Yeah, I mean, it's similar in terms of the piling is the biggest focus. It's like there's a lot of similarity, I suppose, because even that the particular piece of piling equipment, the Vermeer, I forget what numbers and letters followed that word, it is a piece of equipment which is developed specifically for piling on solar farms efficiently. So they all use almost identical equipment. And then, that in terms of the observation that the piling work will take place over a number of months, but will move at a reasonably rapid pace across the site. So levels vary. That was my observation as well. In particular, the solar farm by the airport in Christchurch.
Do you know whether there's been any monitoring done on this on these solar farms as they're being constructed in terms of ground construction?
No, I'm not aware of anything specific being required.
Well, I think that's it, unless you have any other residual concerns that you think we haven't covered?
No, my only other note was on condition 103, where I'd suggest, well, Mr. Ibbotson has suggested a form of condition which I commented on in my evidence, and then there was a slight track change introduced with a trigger, I guess, of a difference of 5 or more decibels, whereas I'd suggested no more than 3, and just confirming that feels like sort of splitting hairs to be getting too worried about whether 4 decibels is in or out. So I'm happy with the wording as was attached to the joint statement of the planning witnesses.
So you're happy with the 5 decibels that's in that condition 103?
Yes.
Okay, look, thank you very much, Mr. Trevor.
Thank you.
Have we got Mr. Vandervelde? Mr. Vandervelde, can you hear us? I think we've got him. Mr. Vandervelde, can you hear us?
Yes, I can. Yes, sorry about that. Just trying to find the right buttons here.
No, that's fine.
Can you hear me okay?
Yep. Have you got a statement you want to read out, or are you just happy to go to questions?
Yeah, I'm happy to go to questions or just go over areas of agreement, disagreement, whichever you think will be easier to cover first.
Let's go over the areas of, don't really need the areas of agreement, but the areas of disagreement would be useful if you want to cover those off, and then we'll see if we've got questions for you from that.
Yeah, okay. So one of the first areas of disagreement, the major one, was where the assessor only considered driver eye levels for large vehicles of 2.5 meters, excuse me, for the state highways, and didn't see the need to include that level of driver eye level height for rural roads, the smaller roads, which I was surprised about, because you're going to get the same, large vehicles in the rural roads like tractors and haulage vehicles, just like you'd have in state highways. So the considering assessment for the large vehicles on all roads should have applied. I felt, particularly from a safety point of view. They also talk about mitigation in terms of shade cloth for the interim mitigation before the landscape plantations. Mitigation mature to 5 meters. 5 meters is a reasonable height to cover the mitigation aspect, but when they talk about the interim measure and just the 2 meter high shade cloth, then obviously that is below the level of the large vehicle driver eye level height of 2.5 meters, which needs to be considered. So they would need to reconsider how high they put the shade cloth. Right, 3 meters is probably a more appropriate height. And there also presumption that by reducing the centroid height of the panels, PV array panels, from 2.4 meters to 1.78, that it didn't require any further assessment. And while I largely agree with that, purely because the geometric angles won't change too much, but the durations and times, they will change and most likely perhaps reduce possibly, but it's not always guaranteed that's what will happen. And so really, rather than presume, they should have carried out a further assessment to properly substantiate that that's actually what happens. And I didn't see any evidence of that. The other thing that I think is probably I think pertinent is the use of mitigation. And this was sometimes where a number of in terms of assessments I've done from a number of other authorities, they've put in mitigation plans, or developers have put in mitigation plans and landscape and so on like that, but don't always consider that in fact may also create a problem. In other words, if they put in landscaping, particularly around intersections, and that once it's fully developed, that itself doesn't create an issue where it obscures view to traffic, oncoming traffic close to an intersection and stuff like that, where you may not have had that before. So that's just another consideration that they may need to take into account. Apart from that, I think that they are the main things. And possibly also really just the what they considered as heights in terms of the dwellings. They had 1.68, I think, was a dwelling height rather than 1.8, because they didn't really take into account the foundation height of the buildings, etc. So in normal circumstance, for observer eye height for a dwelling for a single story would take 1.8 meters as a normal level, and for two-story dwellings about 3.6 meters. And just in terms of if they actually have determined all the two-story houses within the area, within the dwellings that they did consider. So they were the only things, areas of disagreement. Apart from that, overall, I think my results mainly concurred with what they had achieved and obtained as well. And one of the big things of agreement, I think, is from an interim mitigation point of view, they can use what they call adaptive programming of the PV arrays, where they can just set the array angles so that the angles can be set to avoid the times that have been otherwise predicted to create a glare hazard, times that create a glare hazard. And I think also that the adaptive management plan proposed, which also meets accordance, in accordance with condition 56 in the Huanui plan with the glare and glint and glare management plan, that they will try to resolve issues as they arise, or that are any that happen to be raised by the local community there. So happy to answer any questions.
Yep, we'll see what questions we've got. You just start with what you're going
Yeah, so we just heard evidence from the Waipara Collective, and they were talking about the Forge Solar software that's I know is widely used, and there was a concern that that was a black box, so to call. That it's difficult to understand what is in that software and how it operates. What's your take on that from an expert perspective?
Yeah, I can understand that. It's been widely proven. It was developed by by the Sandia Laboratories in the US, and because they had this concern mainly raised around in the transport industry, particularly around airports. And they looked at the impact of glare, obviously from a safety point of view for aircraft and landing and so on like that, but also had wider ramifications in transport in general. Then they widened it to dwellings, etc. But they looked at it from a point of view of impact to just a standard person, if you like, and they tried to look at impact of glare and divide it into impact on the retina of the eye and damage and stuff like that. So they divide into the 3 levels of green, yellow, and red. Red being the worst case where it can create damage to the eye, and yellow where it has, if you close your eye and open again, you're left with an after image, and green glare where it just is a low level glare that you close your eyes and then open again, and you're not left with any after image. And it's widely used globally, and they would have done it, with obviously extensive measurement done using that utility, and just to verify its practicality. And overall, it serves its purpose really well, and it's used extensively, as I say, around the world. And it's been a lot of authorities, like aviation authorities around the world, have recommended its use. It's endorsed as well, like Civil Aviation Safety Authority Australia, UK, FAA, etc., and in Europe as well. Like any utility, it has some limitations, and while overall it provides a very good predictive technique and measurement capability, good 90% or so, you're always going to get a few little areas which can't fully and accurately assess. But overall, as a predictive tool, it allows you to get a good idea of where the potential problems may arise. And from a safety point of view, as I say, it's been widely adapted or adopted across the globe. So I used it for the assessment of Kofi Park and Christchurch Airport, and it has its limitations, but overall, it's a reasonably accurate utility to use for these type of situations and development. Yeah.
All right, thank you. And one of the other questions that they raised in their submission was that there's talk about it being a glint and glare report, yet the four solar outputs and what's mostly talked about is glare only, and with no mention of glint. Is that a terminology thing, or is that more?
Yeah, it's just a terminology thing. Glint is just a short duration. It's not something, and it's low level. Glare is one which you encounter. It's like when you're following a car and your sun is shining off the windscreen or for a subject, a metal reflective, highly reflective object. And obviously you got to put your shades down or put your sunglasses on and stuff like that. And so glare is a far more impactful, if you like, concern to safety, and particularly for vehicles. If you suddenly blinded by glare coming around the corner, and all of a sudden, particularly when the sun's low in the sky and in the evening sort of thing and stuff like that, or for aircraft, particularly in final approach phase, critical phase of landing, the last thing you want is a lot of glare when you're trying to come and land your plane. That sort of thing.
Okay, and so then finally, I mean, given everything you've captured there, I mean, do you think that the proposed condition, which I think might have been slightly updated or at least moved since you last saw it, it's now proposed condition 63, but it covers the glint glare management plan. Does that cover all your concerns? That even if everything hasn't been captured before, that it will be at least during operation?
I think the the big thing, and here in the district council have put in a very good condition with regard to the glint and glare management plan, is that that developer needs to, for the duration of operations of the solar farm, that developer needs to resolve any issues that arise that are brought to attention by the local community. And you're not going to capture every scenario in these things because there are so many, and but this predictive tool will capture the greater amount, if you like, and the more predominant type of issues, which is the main function and the I say the beauty of this utility, the Ford Solar utility. There may be smaller things which are unaccounted for, perturbations like you're not going to count for every undulation in the terrain, for instance, and small gaps in vegetation which in areas which may not have been captured. And I think that the plan that HDC had put in place will just enable to fill those gaps and capture those issues. And I think that's a good way to try and support the local community where they have concerns, so that it's really on their side. That, you know, obviously it's got to be substantiated. If they've got substantiated concerns, and they've got the evidence and shows here's a problem, they can then, the developer, according to this, I see, must then try and resolve that issue, whatever it means.
Okay, thank you very much. Just a couple of other questions. You referred to the fact that the assessors had only included the state highway and not rural roads. Which rural roads do you consider needed to be assessed?
All the ones which I think were in their report. I think they had Mackenzie Drive. I can't remember all the roads are there. They had State Highway 7 was the main one, which they looked at from both directions for 2.5 meters. And then a number of other roads which they included. But I noted they only, from the information I saw and their attachments from the analysis and modeling, it was only for 1.5 meter driver eye level height, which is the smaller vehicles. So essentially, from a safety point of view, you'd want to look at the worst case scenario and then include the driver eye level height, which is the 2.5 meter, and that captures the smaller guys, the smaller vehicles as well.
What sort of distance to a road would you need to consider? When does it get to a point where you don't need to consider it?
How do you mean?
So if the road is 1 kilometre away, or 2 kilometres away, or 3 kilometres away, what's the
okay, right, in terms of distance?
Distance between the solar farm and the road?
Yeah, I understand what you mean. That's tricky because what happens is with glare, like with light intensity, is that it falls off according to what we call an inverse square law. And that is, if you double the distance, the intensity is quartered. If you triple the distance, the intensity drops down to a ninth, etc. So it drops off fairly rapidly. But it depends on what the intensity is to start with. And the size and other things like that. So the fall off of intensity is very rapid. And in terms of whether you have your squint your eyes or close your eyes, other things that change in terms of closeness of that distance as well. And it's hard to say what it is, but that's why they try to differentiate between green or yellow and red level in terms of this predictive tool. And it's only, I think, like IDP have looked at it in the first 2 kilometers range within the solar farm. And beyond that, as I say, it's an inverse square law that the intensity drops off very rapidly. And so within the 2 kilometer that they consider ready for dwellings and roads, that's taken as a fairly standard approach. And beyond that, the impacts, because the Edinburgh Square Law don't really seem as impactful, if you like.
And that presumably needs to be direct line of sight.
Exactly. Yes. Yes. A lot of the vehicles and the modeling is done based on a peripheral vision of plus or minus 50 degrees, both for direction of traffic and even aircraft and so on like that. Yeah, from a transport point of view.
Okay, look, that's all the questions we've got. Thank you very much.
Thank you.
Okay. Where's the cable?
Make yourself comfortable. We might be here or we won't. Yeah, you got a statement you're going to read out.
Yes, I've got a couple of pages of speaking notes, so just responding to things that have been raised, also landscape points on conditions, and I went through some practical measures as well.
Okay.
So firstly, the limits of visual mitigation. A lot has been asked of visual mitigation in this application. It is presented as a solution to integrate proposal into this location and to resolve concerns about landscape character and values. While screening can reduce what is seen, visual amenity derives from distinct local character and values. The relevant question is the effects for development of this type and scale on those values, physical, associative, and perceptual. The reliance on visual mitigation for this application has further pitfalls in that the photo montages overstate planting establishment in this climate, and landscape management concerns exist around water access and irrigation. The issue of NIMBYism was raised by a couple of submitters. This concept assumes an objection is in self-interest. However, there are concerns grounded in the specific attributes of this place. It is fitting that the site has also been described as Waipara's front yard, a locally prominent location situated between the scenic state highway and neighbours' outlooks, with high landscape legibility and embodied landscape values. So that's generally, and I've gone on to look at some specifics that have been raised. So shelter belts, which are a permitted activity and are generically characteristic of the rural environment. But landscape assessment concerns itself with the specific, with an outcome considered in context, not with an element in isolation. A permitted activity can still result in an unfortunate outcome on the ground. Once established, the proposed shelter belts screen or partially screen the application from certain directions. However, this will involve a mechanically trimmed utilitarian green wall extending 3.5 kilometres along road frontage. At this scale, it will be a singular landscape feature within the application's view shed. It will line a scenic and predominantly open stretch of road, detracting from and partly obscuring well-discussed vistas of surrounding hills. And the interplay of light and landform that gives this corridor its perceptual distinctiveness. The existing shelter belt sections fronting the road total only about 600 metres in length as measured off plans. Another thing I noted on that was that this is visible, the shift and photo montage viewpoint too. A submitter has already captured this type of issue for the application, and that there is a risk of creating a problem by solving a problem. With regards to effects relating updated findings, I note that following visits to some neighbouring properties, Mr. Cocker has revised 3 visual receptor ratings upwards, i.e. acknowledging a higher level of adverse effects than his original assessment recognised. while at the same time introducing additional mitigation with screening to the leading edge of terraces. With regards to landscape management concerns, this has been raised by neighbours with local horticultural expertise relevant to climate conditions and soil type. The speed and likelihood of successful planting establishment has been described as variable from year to year. One practical risk raised is that fast-growing plants can fail in high winds because irrigation can produce shallow root systems. The implication for landscape outcomes are direct. Screen planting failure or failure to thrive negates visual mitigation assurance. Its effectiveness is demonstrated as variable for neighbouring properties. So for effects timeframes, I have considered what a 35-year-old timeframe means in human terms, such as cycles of adjacent property ownership, a local childhood, or the best part of a career in a vineyard. A submitter made a similar observation. The application is not a permanent outcome as proposed, but it is a long-term one. The short-term effects of the application have been notably under-addressed. The short-term potential effects of solar farms are understood as acutely relevant in landscape assessment practice because panels are low in height, limiting how long it takes for screening planting to exceed them, compared to buildings, for instance, but the breadth of panel array areas can be extensive. For elevated neighbours, concerns are more ongoing as they see over and across array areas rather than merely to the first row. Taking in an outlook each day involves noticing transient qualities that form part of landscape value: light, season, weather. Short-term effects carry real weight when considered over the time it takes for screening and planting to become effective. That has not been demonstrated here as taking less than 5 years, and local conditions suggest potentially longer timeframes. So just to generally set out with the conditions, I've just summarised generally where we're going with thoughts on the landscape ones, not the specific wording. So what we got to was that the irrigation and water supplies to be secured first before any consent works or physical works are to commence. That the irrigation and water supply is first confirmed and secured. The timing of planting, so we looked at priority planting areas and then Mr. Cobb went away to have a look at what they could feasibly do and came back and suggested that they could begin with the leading edge of terrace planting to be implemented in the first season after consent is granted, and that all remaining screening planting is to be implemented in the first growing season after fencing is installed and before panel array installation. So practical measures, I've got some recommendations that have been put forward. I've also discussed, well, these are things raised during the hearing or they've discussed with Mr. Cocker in the course of reviewing landscape conditions or the planting priority areas. So I recommend that the 3 barbed wire rows, particularly fronting State Highway 7, are removed. Barbed wire top security fencing is not a consistent treatment across solar projects. It will be visible above shade cloth at the height it's currently proposed, along a highly prominent road frontage, reinforcing associations and perceptions inconsistent with the current character of the landscape. I recommend that the road frontage shelter belt height is reduced from 5 metres to 3.5. The 5 metre height was proposed for double height planting. A reduction to 3.5 would proportionately improve use to the hills beyond the site for road users, while still providing effective screening at approximately 3/4 of a metre above the panel height. So, and I looked at the idea of if we could provide a true mixed species shelter belt to short internal boundaries perpendicular to the road on approach to the site, that this would improve on-approach views for road users and provide a better boundary treatment for the adjacent new subdivision allotments. To reinstate and confirm the use of taller 1.8 metre grade planting stock in key locations as per the planting schedule. And Mr. Crocker was going to come back with details of what they'd be able to do, extents and amount of that. And to make mitigation planting and possible bunding where sought available on neighbouring properties where it can make a material difference to mitigation outcomes, such as the 247 Mackenzie's Road. That's what I've got.
Those first two, irrigation and the private planting, has that been agreed?
Yes.
And but these other ones are your recommendations,
So the practical measures are my recommendations.
right? And they're not agreed. As you can imagine, I'm not asking many of the questions.
Right, yeah, so it was great that you were here last week, so I think you've heard most of this, and you've captured some of that in your evidence, probably, or your statement just then. Can we say, what experience do you have on other solar farms? Can you just take me through, have you visited any?
So I have been involved with solar farm proposals for about the last 5 years. The first one I did, Tauhead's Tiara Hill West, has just finished construction. Consequently, I hadn't seen a lot that were finally built until I got, because they're on the North Island. But I did get to see Kowhai Park Friday night, so I have now seen one that's been fully constructed.
Okay, cool. All right. And in your assessment here, what submitter properties have you visited?
I have visited all of Mackenzie's Road properties that look directly to the site over the Wiki Creek. I've also been to at least one property on Glenmark Drive and 27 Bain Road as well.
Okay. I want to just quickly turn to the methodology that Mr. Crocker has used. You were quite critical of that in your evidence and your initial peer review. You would have heard me asking questions to him about that methodology. Where do you sit with that now in terms of his method and his approach?
I can see obviously he's increased what is possible, that he has been to some of the sites and increased some of the neighbours' properties and increased the mitigation planting. But what I was concerned about, and still comes through as evidence, is it does seem like there's an overplaying of the detracting features on the landscape. It's still a rural landscape where open space dominates over built form. We did agree in the joint witness statement that it's modified, not a highly modified environment, which I think is important. It's problematic to me to describe this type of environment as highly modified, because then what's left to describe an urban environment?
Yeah, that makes sense.
It was also that the English guidelines he was relying on, it was describing things as less than national park as ordinary, and it was quite generic. So it didn't have that response to place and distinct character that Te Tangi Te Manu was through.
Do you think he's now got there through his evidence and his questioning?
It's closer. I still think that it overplays the ability of visual mitigation to address effects or address landscape effects more broadly.
Thank you. One of the things that you had been requesting, I think several times, was a ZTV to understand visibility. Do you think that's still needed, or do you have a pretty good idea where the solar farm's going to be visible from?
I think the fact it was really, my concern was that because when I wrote my evidence, it was based on reviewing his assessment, and at that time he had just done a reciprocal view analysis, so from the site looking out.
Yes.
And there were problems with that. So I did put forward doing ZTV, but he has picked up by going to sites and by having the viewpoints from sites, that has effectively addressed that issue.
Okay.
Also from names.
And so just on that visual catchment, you would have heard me ask the Waipara Collective this question. Where would a tourist see this solar farm from?
So I would agree, you're going to obviously see it as you're driving along the state highway.
Yeah.
But also if you start exploring more locally, going to vineyards or boutique providers of food or anything else, or staying locally, then you were going to see it from those locations and other places you visit, also trails, walkways, but sorry, you're talking about seeing the site. So it just depends on the visibility that those locations have, if they're within view shed, and also the Pass Railway.
Okay, yep, so the Waipara Railway is one, State Highway 7 is one. I mean, in the village, they're all residential properties, aren't they? Just let's not count Mackenzie Road, but they're all residential, I think. So
Yes.
you wouldn't see it from the village. And then in Mackenzie Road, there's a couple of properties there.
Sorry, just to go back to the village, the extent to which you can, and I'm just trying to remember if it's publicly accessible, getting down the creek itself. We were there with, I think we were there with the landowner, so I don't know that that was publicly accessible.
No, about that. Okay. But it's only snapshots, if anything, from the village, so right? Unless you're a resident. If you're a resident, you know, the village is different, but from a tourist or a public perspective.
Well, the the Glenmark Railway Station, so the train stop is there.
Oh yeah.
That's a point that same aspect
Mm-hmm.
where visitors would be congregation to.
Okay. Right. Hi, no, Cass?
You would be seeing it if it's visible. I haven't been up there, so it's the same kind of looking at Google photos and things, but it's the same thing where you take a broader view and it's a small part within a broader view if you've got the ability to see it from there.
Yeah. Right, let's talk about planting. I want to focus firstly on the screening vegetation. You mentioned just in your statement probably a while ago that you think that the visualizations overestimate that. I'm going to come back to the visualizations in a second. Can we just talk about how are we going to go about understanding growth rates? We've heard a lot from submitters, but we haven't had any expert evidence. We've had a lot of people say that you could grow, could not grow. We've heard different things about water. When you've been here, you've heard all of those. Where do we get to? How do we get to a decision that we have relative assurance of how long the screening vegetation, and that's really the conifers, how long they're going to take to grow and how long they're going to take to be effective?
I'll be honest that both myself and Mr. Cochran are coming at this as generalists, as landscape planners who work on proposals in various locations, and that getting into horticultural detail, you start talking to local experts in horticulture and ecology, which is what he did, and talking to local nursery people. So we start looking these things up, but also seeking local advice, and that's probably good practice when you work in different locations.
So have we had any of that through this hearing? Have you heard any concrete evidence through this hearing so far of how long it's going to take for that screening vegetation to get established and become effective?
There is a consistent theme that it was overestimation in the visual montages. I think there is a consistent theme that what I've looked at is you're not going to be less than 5 years, and that might be to get to the height of the panels.
Not less than 5 years.
Yeah. And that's not maturity, that's probably more just the height of the panels.
Which is what, 2.5?
The 2.7, 2.5, 2.7 metres. And that might be fine at the roadside, but the difficulty is, you know, if you're looking down, then it's just tougher to solve.
Yes, yeah, I'm going to come back to the views from those properties later. But yeah, just trying to get a handle on that. So I think Mr. Cocker said that it would be a year later, that, you know, than what he had said in his evidence. So that would indicate 6 years the vegetation would be effective. What's your take on that?
Yes, that may be correct, but at the same time, I would also acknowledge that the neighbours here aren't just people looking at an application, they're people with horticultural experience in these conditions on stony soils, and also aware of you know, how much water needs to be put on plants, have asked questions about the water take and things. So I think they may, you know, there is merit in some of the comments that come through there. And some of those risks too about shallow rooting plants in stony soils. Even Dr. Merck was saying that things grow very, very slowly. So
I think his reference was to natives.
to natives. Oh yeah, no, absolutely. He was talking about how slowly.
I
they
asked him a
grow.
specific question
Yes.
about exotics, and he didn't know.
No, it didn't go into exotics as far.
Um,
So these are the two species are species that do well in tough conditions and dry conditions. They don't like big feet. That's cypress and Thalia, but that also slows them down. You know, in dry conditions, they do start slowing down. So it's close to 0.5 metre rather than 1.5 metre a year.
But we will have irrigation.
As long as it all works, and it's I mean, I personally don't know whether that's going to affect the if that puts the roots at risk in high winds. So that's when you start talking to the local nursery owners.
And so where you land on this is that it, after 5 years, it still will not be effective at providing screening. It will take longer. Is that right? Is that what you said?
My sense is that it's going to take at least 5 years to get to the height of the panels,
Right.
and which is works on the State Highway, but you do have height issues and other things. I mean,
Yeah.
yes, for the top terrace, the neighbours opposite, but things could still go. You can still have very dry summers, very strong winds, and all of those things happen.
And so that's height, that's not density.
No.
Okay. And so how long do you think to get to the density? Sorry to push you on this, but it's probably one of the most critical issues that we're trying to figure out. So what sort of time period do you think we'll get to being of a density that's effective?
I don't have exact precise opinion on that. And it does depend on the management too. So as soon as they get topped, you start offsetting the topical dominance of that, and they start spreading more. So it does depend on how they manage too.
So would you say there's a high level uncertainty on this?
Yes.
Can I just building on Brad's said, can I ask you therefore, in terms of the two properties where you agree that there is significant effects, what's your time period on that? I think at the moment, Mr. Fox is saying 1 to 5 years. Is your period longer than that? What would you say?
So I would say you at least 5 to 10, but then we don't have
1 to 10.
Sorry, 5 to 10. But
5 to 10 would also be significant.
yes, I haven't seen it demonstrated that you're going to get full screening with the planting going in for some of the neighbours, particularly with the lower terraces. So what we're not sure on is the extent of panels they will see for the duration of the proposal, to really be precise about that. All we can say is that, you know, the sims are on the optimistic side.
Yeah, I've got quite a few more questions. I'm trying to decide whether I do jump into that now, but I think I'm going to come back to it because I want to go through the table with you. I think we'll come back to that point. I think it's probably easiest. You mentioned using the 1.8 metre species as a plant, as a planting instead of the PB2. It was a question I asked as well.
Mhm.
I mean, my experience is that with a 1.8 metre plant, you're taking a plant that's grown up in a nursery in a sheltered position, and then you're putting it into a paddock that's not necessarily sheltered, and therefore it becomes more vulnerable. So there's a trade-off, I think. Does that change your view on perhaps whether you would use 1.8? Would it, and based on the, we need hardy species?
So I'm also aware that when you plant smaller, that they can be tougher where they're going in. It was really to look at the opportunity to shoulder or boastal to see if you get anything better out of strategically mixing those through.
Ah, okay. So you do a mix.
Yeah.
Okay, I understand that. Sort of a shelter valves, you mentioned that. I mean, in terms of just construction, but infrastructure projects in a more general sense, I mean, would you say that generally it's hard to mitigate large infrastructure anyway, no matter what it is?
Yes.
Yeah. So this isn't different to any other large construction effect.
No different, but well,
Yeah.
I'm just thinking of Christchurch post-earthquakes, and you live with noise, you live with long-term implications of things being built, and it's loud, piling different techniques and things. I understand that, but it is 2 years could feel like a long time.
Okay, let's look at the visualizations. You've already pointed out some limitations with those. I don't know if it's helpful to have a look at some visualizations. You mentioned visualization 2. I mean, it's a good one to start with. Yep. So I think we've covered this off, but I just want to really capture it. So that's visualization says planting year 3. Based on that conversation, you don't think that's realistic? Year 3.
No.
What would you put? Based on again what we've talked about and the limitations that you have. I mean, what would be your experience of seeing something like that? How old would you anticipate that would be?
I would say that's close to year 5. The other thing is that when you're looking at the appearance of this, it's before it gets pruned as well. So your long-term outcome is far more that green rectangular, green wall that will look far more utilitarian.
Yeah. What do you think the height of that is?
It's top the panels, so it's at least 3 meters, might be 5 meters.
Just looking at the fence posts there.
Yeah, so it's quite tall. So it's
at least 5, isn't it?
Yes. And that was why I raised the idea too of reducing that, because proportionately that gives you the ability to see more of the view beyond, which you can, when you're looking at those two full length ones and you compare that, there's that distinction. And on previous solar farms I've been involved with, the community feedback spoken to neighbours has been that mattered to them what they see above and beyond. And that's come through here too.
And then I think we've got some similar situation, haven't we, with the visualizations from, say, 247 Kenzie's Road. The planting in there is overemphasized based on what we've said.
Yeah, and it's I haven't got that one open, but I was looking at that over the weekend again. And when you look at how high up, the top of the panels are and their outlook, that's that's a good proportion of the depth of their outlook.
Yeah. Okay, we'll come back to effects, but trust me, I've got a page to go there. So based on these visualizations, we don't have any visualizations that show that first 5 years, do we?
No.
So how have you gone about assessing effects of the construction and that first 5 years?
It's simply from understanding that you are looking at extensive area of solar panels and worked on projects, and also, had this thing shown on other projects. So I have done day one with Sims, and having been driven along with co-flow parks as well.
Yeah, but that's, it's quite a limitation, isn't it, not having.
Yes, in terms of expressing that, being able to demonstrate that. I mean, you also, because at the other end you don't have, well, there's now year 10, so we just count that as planting at maturity, but for a while we didn't have, those establishment type systems either.
So those year 10 ones, you would say they are reasonably accurate? Like, I'm looking at the one, maybe it would be useful to bring up that one for 247. Because that shows the native planting as well.
I've found the year 5.
So we have two, well, we have the existing, then we have a planting year 5 and then planting year 10. And I think we've probably covered the evergreen, the exotic hedging. What about the native planting in there? Is that based on, again, what you've heard of the ecologists and submitters? Do you think that's a reasonable expectation that native planting will be that visible?
I think there are problems, particularly with, I go back to detail K, which I think sets it out because there's some, there's some variability in there. But what that shows is that the native planting is on a slope lower than the panels. So you're starting at a low height, they're lower species, they're not put in the ground at the same height as the panels. And then there are some views which are higher than that. So what you're asking of plants in tough conditions, in terms of mitigation, they're not offering, you know, that's a big call and ask.
And I think we heard, didn't we, there's something about they were divaricating species. I can't recall what was in the management
There's
plan.
really big here and other things as a prostrate co-fi. So, I mean, they're not going to put plants in it, that will potentially block shade panels, but they're also, they're low growing and they're on a slope at lower level panels.
Yeah. So where we come to is back to this visualization. Is it representative of that planting, or
I think it's the visualizations are optimistic, and when the discussion was too by different experts that you're looking at 10 to 30 centimeters growth a year in tough conditions, not facing embankments, slopes.
Okay. We heard a lot from submitters on perceptual landscape values and associational landscape values, and I think you've covered quite a lot of that in your evidence anyway. Is there anything particular that you pick up from submitters, what you've heard over the last few days?
Yeah, I wanted to discuss, and it's not the site specifically, but you've asked people about Waipara Park and you've asked people about wind farms. And just on that, to me, they are quite different. I have driven the road up through the wind turbines on way to Palmerston North, and you are going through something which can feel sculptural and interesting as you drive through beneath them at different angles. So I can understand how with wind turbines there is some interest to that sculptural aesthetic. Going through Kowhai Park, you have in that location, you have barbed wire fence of the airport on one side, and on the other side you have barbed wire fencing, security fencing of the panels. So that is a context that makes sense, that sits there. The other thing too is that in a planning environment, I understand that obviously that's rural zoning, but I would anticipate that the noise contour for the airport actually means you're not going to have, you know, the same housing around the
Right.
and I haven't looked at that. That's something we're going
to. Just on that, is there any? I haven't driven through it land a number of times. Is there any landscaping on that? Did you see any landscaping around the road?
If there is, it's fruit train grade. I didn't get up, have a good look, it would still be right there. But you can't confuse that with anything that has a sculptural interest or appeal or something. You're going there because you wonder what it's like, but if anything, it's a bit dystopian. It's not appealing. It's, you know, it's bringing it as well.
Yeah, I think it could be, again, in trouble there. I think there are people that, I think Mr. Andrews probably quite likes looking at solar panels.
Well, yeah, I mean, it's a good thing, but they need to be integrated and located well, and that's important. And it's about the appropriate development in the appropriate place.
Okay, so let's take that to its next question, which is where is the appropriate place?
So
you mentioned the airport, but
yeah. So in my experience, I understand from having worked with developers that they're looking for locations in proximity to substations. It's unfortunate that this is also alongside a scenic highway. To me, it is far more appropriate when you have your secondary roads, or you've got your among larger land parcels, so be it the dairy farming, the forestry, where you've got less neighbours, and neighbours are more sensitive where they're elevated as well. So it really depends how those factors add up. And when you've got other things such as landform, which is, you know, more supportive, that's also an advantage. So the slope is containment in itself.
So the Todd Energy proposal, for example, on the Napier Taupo Road, and you may not have seen it or read it, but it's viewed from a state highway, which is a named state highway, Thermal Explorer Highway, and the viewing angle of that solar farm from the road is in a very elevated position. You'll see the whole thing, several hundred hectares of it. So how do we consider that? How do we bring that into this context? Because there's a context that's rural, highly visible. There are neighbours, and it's been granted. What makes this site different to that, or other places, whether on a state highway or have neighbours?
I don't know a whole lot about that one. I haven't been there, but I don't know if it's more isolated. I don't know about the land parcel sizes, the number of neighbours, or their aspects towards it, or what mitigation or how they've dealt with those individually to actually comment on that.
And so one of the things that you do talk about is the legibility of the landform, terraces, etc. That's not visible from the state highway.
No, it's not visible from the side. How it's visible is the see the land. Well, you see the top terrace. There, you see obviously the surrounding hills. Things. It's going. That's definitely primarily the neighbours and their effect with that shift of water.
And what other activities could happen that might diminish that? I mean, the vineyard is obvious, would that diminish the legibility of those terraces?
Well, it's going to, I would anticipate, it's going to be on anticipated on flats, but you have your perceptual associated value, so that is definitely associated with horticultural production and specifically with the location in the area as well. So it is not an entirely different land use in the place.
Well, what about something like pine forest? If the entire site was planted in pine forest?
Yeah, you would definitely not see the hills anymore that way. So it's, I mean, these are all possible outcomes, but again, you're looking at different associative and values, and that's what, you have permitted activities and that's what we talked about, and also considering things in context.
What's the native regeneration planting do for the terraces?
If it establishes them, it will soften them, but I think that's the opposite end from making things legible, because planting obviously variable heights will cloak things. It's not, offers ecological benefit and it may soften things. I don't think that it's really offering fragmentation effectively with the scale of the development.
So you're sort of trading off that legibility for the
yes,
but
you're putting native plants in, so you're definitely offering something that affords a landscape value.
So where do you stand on that? Is it the legibility of the native plants which is more important to you?
I'm probably completely neutral on that outcome. There's nothing wrong with putting planting in. That's a good thing of itself. But the qualities of that, I would say, and what I've outlined in my evidence is the susceptibility to the geometric patterns and the nature of the development of the solar farm.
Just before we get to that table, something that came up during one of the submitters was in relation to the natural character of Weki Creek. I think there was a suggestion that it had high natural character. Have you done an assessment of natural character on the creek?
No, but I've taken that as this isn't developing in the margins or in the down in the creek setting that's up on the terraces set back from that. So taking that my thoughts were, so I haven't done the natural character assessment. I can see as well as some things there, obviously. But having reviewed what Mr. Cock has done, we came to agreement that the natural character effects were not a key concern of the development where it is in relation to the creek.
Thank you. So, yeah, I'd like to pick up on the joint witness statement and the table of findings, I think it's called.
Yeah.
And I just wondered if we could just go through this just to confirm where you're at and get a bit more information about those. So firstly, based on our conversation we've just been having, what do you see as short-term and what do you see as long-term in terms of that table?
So short term is up to actually achieving for the state highway, it's going to be achieving effective mitigation. So that's topping the height of the panels for view.
Right, so we don't have a time frame.
Not a time frame, but a height of planting.
Okay. And then in terms of the other dwellings, because you've done an assessment of short term versus long term for other dwellings and they do change. So for that, what's the time frame for?
So I haven't attached a time frame to it, but really looking at that says what you're actually going to achieve in the long term of the project. Just because you've got some variables and some unknowns with how successful the planting will be or how long it's going to take to establish.
And so where we land on State Highway 7 is moderate high in the short term, moderate in the long term. Moderate high because
of the change in character and derived immunity of introducing panels and also with security fencing and barbed wire in front. Well, yes, I acknowledge that there's now going to be screening, but you've still got a shift in character to a totally different land use for that scale in this place. One thing I'd say too is that the form and the area shape of the application does exacerbate some of the effects of it because you've got views that stretched out like this. You've got views, the key views that are along sides of it.
okay, so it's almost the length as well as anything.
Yeah.
Okay.
Can I just ask in terms of the assessment, does the removal of existing shelter belts, both internally and along State Highway, play into it?
Can you expand on that a bit more?
So if you're driving down there at the moment, you've got shelter belts down the State Highway which block those views already, and then the shelter belts going across which also block those views. If they are removed and the view and you get more open view, is that if you factor that into it?
So I think it's
so if you like, there's potentially, I don't know, there's plenty of positive as opposed to
of cutting the shelter belts down. Yeah, I understand what you're saying, but also like that viewpoint too, you're looking at a existing open viewpoint. And when we measured them, because you talked about shelter belts about 1 kilometre in length, and what we measured off the plan was 600 metres, so that's not more than a third of the length of that frontage.
We would agree that that's what we were looking at on viewpoint 2 is probably over.
Yeah. So, so the height is overemphasized.
And actually on that viewpoint too, that view's also changed because we've now got a consented subdivision in the foreground of that view. So that view could be affected by a dwelling. Okay. And so moderate high, I'm just trying to think about the 7-point scale. So that's not significant. That's more than minor, but not significant for the highway. What you said.
Yeah.
And then as that vegetation grows, it'll drop down 1 point. Then we get to Mackenzie's Road and the rail carriages at the end there, they're right on the edge. So did you go there? Yeah, we haven't actually been to that one. Okay, so that's moderate high. And then in particular, I think 253 and 247, very similar in effects there. So that is hitting significant in the short term high. It's 251 Mackenzie's Road and 247 Mackenzie's Road.
Yes.
And it does reduce over time, but only by 1 point, whereas Mr. Cocker goes from high to low.
Yeah.
I mean, that's quite a difference in opinion between the two. So what's your reason for not reducing? This is what we're going to come back to.
So when in reading Mr. Cocker's table of the effects assessment, he talks about the panels not disrupting the view to the hills, whereas I've looked at the shift in character that the panels introduce for the breadth of the array area, and the shift and that values attached to that, as opposed to, you know, that don't take away the view to the hills beyond.
Right.
They don't block that.
And so what are you saying with that moderate high, that the vegetation won't provide that screening, is what we're talking about earlier?
It hasn't been demonstrated to actually achieve. Yeah, you're still going to see, one stand, you're still going to see panels for the duration of the life cycle of the solar farm.
Yeah. And so Mr. Cocker has suggested that he hasn't shied away from a person seeing the panels, but he says that the presence of the vegetation between the panels helps to break up that view and allow the terraces to still be visible. What's your take on that?
So I've stood on the sites as well, and I am probably more concerned about the introduction of the panels into that outlook of the shift associated with that. And again, I don't think that fracturing is effective maybe portrayed, and the weighting of that for the shift, given the breadth of the panel areas together, it's, you know, it's like this. And you get that too because of they're not, you know, not considering something that's your immediate fence, like next door in an urban environment. When you step back, you see a bigger view. So that's what they're taking in.
Yeah. And in your experience of working on other solar farms, have you visited properties that are affected in this way elsewhere?
Yes.
And where have they landed up on the rate?
So hang on. I have visited properties where they've had elevated views, and we have introduced planting and been able to screen in the long term. And actually, it is a discussion with specific neighbours, but we did get to the point where they were starting to say we wanted, and we were just trying to think, we did get better coverage just with the heights and the distance. We did get better long-term coverage. And what they were starting to ask was questions about, well, you've done poplars to shoulder the view, but we want less of them because we want to see mountain ranges. So not exactly the same.
Right. So this would you say this is, you know, one of the worst you've seen, or up there, or you know?
It is because of the values. So that's why I'm cautioned that some of those statements in support are more generic rather than specific, or relate, that the comments in support relate to generic understandings of rural environments rather than like working through and consistently considering the effects in relation to the distinct qualities of the place.
And if, you know, there has been talk, and I think one submitter at 247 even suggested that they might be up for mitigation if that's the only option. I mean, what would be the effect of the mitigation in itself? Would that have an effect?
So this is the idea of putting funding and planting on their property. As a daytime noise, but hesitant of planting on top of bunting because it's inherently dry in itself, you're lifting the ground level. But it's going to block the view more effectively than what you can do on site, just by nature of the relationship of height and distance with where the sites and panels are. So you will improve the level of screening afforded, which means they get clearer, visual separation in terms of what they want to do, what they're looking for. I don't know that at this point that it was still offering that. I think that was an earlier offer that was made, but that's not.
But would that screening, if it's on their property, would it have its own effects?
That would enclose their property more in terms of the outlook. But at that point, you're comparing an outlook to, what they can still see at the solar farm with being slightly more close and you'll be trying to manage the heights.
Okay, and then there's some other properties down there which changed quite dramatically, like 249 Mackenzie's Road, I think, drops quite considerably.
Up 249. If I've got the numbers right, 249 is the property, parents' property behind 247.
Yeah. And then at 161 and 163 Mackenzie's, I think 163 is Miss Kelsey's property. You said moderate high to high, so we have a 7-point scale, and you can split the difference.
Yeah, it's close, but I didn't think it was quite as bad as the 247. But those two houses, when you're standing there, they feel very similar level. 161 wasn't an occupied house, the circular one in plan view, but the extent to which you still consider that as a dwelling and it's not occupied, I understand the owner has booked into for the vineyards.
Okay. So I guess, the question for us is, does that meet the threshold of significant? Those two properties.
Comes down to the planting. Comes down to the outcome of that. It comes down to, do they work through with the landowners if they can do any more mitigation on their own properties as well.
Well, we're talking in the short term before that planting's established.
For that, I would say it probably sits just under, because if I'm comparing it to the extent to how what it was like to stand in front of 247 and look at the side, I would say that these ones are nearly there.
139 to 73, etc. You put moderate high. Then we get to Glenmark Drive. We did manage to visit a property in Glenmark Drive number 25, I think. So we have seen the view from that. So you put those at moderate high. Oh, and 91 because but so in that first set of 5 to 47, I think that's the lower series of houses before you go up the hill, isn't it?
Yeah.
55 driveways at the top there, and then it goes round to where the shop is. Okay, so so moderate high, so that puts those properties on a similar level to what we just discussed Miss Kelsey's property at 163. So just talk me through how you get to that level.
So if anything, they are slightly less than those. Because those houses are I think they got the mitigation, if it's established as effectively and you're now doing top of terrace planting, they will benefit more from that, for those properties.
And then 63 to 115, I think you put it moderate. Would you say that's a worst case scenario perhaps for, so I think there might be some properties in that mix that probably don't have a view at all.
But this is the things you need, it makes a difference to those properties. And that was one of the things that I definitely saw when I first looked at this application. So it definitely makes a difference to look from going back to the site.
And then Waipara, as we said, so that's both from the railway station and then from the higher bit of the pass as you go through that. Okay, thank you. That's been useful to go through that. So a question then is, how would we reduce the effects on those moderate to high properties? What would be the mitigation or the remedying or the avoidance or whatever? What options have we got to us, do you think? How could we reduce those?
You would be mitigating them. The most effective methods may be looking at mitigation on the neighbours' properties in discussion with those neighbours. But again, you're looking at the difference between, do they see a solar farm or do they have an enclosed outlook? And definitely managing the height so that they can still have some look to the aspect above and beyond. Or
I guess if the solar farm was removed from the lower terraces and sat on the upper terrace only,
yes.
How effective would that be?
Yes, because then you would definitely, because it's more at level, your mitigation planting is more effective because you're more looking at the end rows rather than above across the range areas.
So what difference do you think that would have to your ratings if that was to be?
That would change the, it would definitely have a notable effect on the long-term ratings, but it would probably be the short-term ones as well, because the overall point volume or depth of panel areas they're looking at as well.
Reduced from significant for those two properties, and others would reduce as well, to be fair. If we could.
Yes, I think you get them on the same.
Yes. And then based on everything you've heard, everything we've talked about, where do you land on the proposal now?
As it is?
As a overall final conclusion, as it's presented, as everything you've heard.
I don't think that visual mitigation solves the shift in character and the overall landscape effects. I think that's too big a kind of jump in logic to do that in terms of how we access landscape across the different dimensions.
Thank you. So. Great.
Okay,
thank you very much. Appreciate that.
You've got a statement as well, haven't you?
I do, yes.
Okay. Sorry, I get so many things open. Okay, got it.
Alright. My full name is Nicola Joy Kirby. I am a senior planner at Hurunui District Council and the Section 42A reporting officer for this application. I've listened carefully to the evidence of the applicant and evidence of submitters and listened to the questions of the commissioners. This has informed my statement today. As I did not reach a conclusion in my office's Section 42A report, I would like to first outline my conclusion on effects. In terms of landscape visual effects, I relied on the evidence of Ms. Annan and adopt my preliminary conclusion that there are actual potential adverse landscape visual effects over both the short and long term that have not been avoided, remedied, or mitigated. In terms of ecological effects, on the basis of the proposed amendment to remove panels from the area of unauthorised clearance of the Matagari and the conditions proposed by the applicant, I'm satisfied that actual potential ecological effects will be mitigated. In relation to glint and glare transport, I had not previously reached a conclusion because I understood the applicant was liaising with New Zealand Transport Agency, Waka Kotahi. NZTA has now withdrawn its submission. As the road controlling authority for Waipara Flat Road State Highway 7, I'm satisfied that actual potential transport effects will be mitigated. In terms of glint and glare, I relied on the evidence of Mr. Van der Bowden. With a glint and glare management plan as proposed as a condition of consent, I am satisfied that actual potential effects will be mitigated. In terms of positive effects, I have noted these from paragraph 257 of my evidence. I also acknowledge the additional explanation provided in the evidence of Mr. Andrews. Provided the acceptability of the removal of the Matagari area is confirmed by commissioners, I consider it appropriate to add the terrace riser revegetation to the positive effects. In my Section 42A report from paragraph 337, I outlined my interpretation of the relevant objective and policy framework in the Hurunui District Plan. In my opinion, of particular importance to this consideration are the objectives and policies in Chapter 3 Rural and Chapter 7 Energy. With regard to Chapter 3 Rural, in my opinion, the proposal is contrary to Policy 3.5. While Policy 3.5 seeks to enable a variety of activities to occur in rural areas, I do not consider the proposal manages adverse effects on the character and amenity values. In terms of Objective 3.1, I consider the character and amenity values of the site are not retained. However, I do not consider this proposal affects the character and amenity values of the rural area as a whole. Would you like me to go further into Policy 3.5 now or continue just?
No, you continue because I think there's be some questions around that anyway. So yeah, let's just carry on.
With regard to Chapter 7 Energy, my interpretation is the objectives and policies are enabling of energy, particularly renewable energy, providing conflicts between energy activities and sensitive environments are managed, and as per Policy 7.6, adverse effects are minimised. I note the language is subtly different for renewable to non-renewable energy, which has a stronger language in terms of effects management. Commissioner Crystal discussed the meaning of sensitive environments with Ms. Alcamel during her evidence. In preparing my Section 42A report, I was trying to establish for myself what the Hurunui District Plan means by sensitive environments. I noticed that Policy 7.1 Part 2 appears to indicate that Policies 7.6 and 7.7 should identify what sensitive environments are, which they do not. I looked back at the documentation supporting the District Plan review. I found that originally the proposed Policy 7.6 set out what was intended by sensitive environments. This was outstanding natural landscape areas, areas of significant Indigenous biodiversity, the coastal environment, outstanding natural character areas, urban areas, the Hamner Basin, and Hurunui Lakes area. Submissions on these were upheld by the commissioners and deleted. However, the references in other parts of this chapter were not removed. In my opinion, the interpretation Commissioner Crystal took from Chapter 5 subdivisions and discussed with Ms. Alcamel is generally consistent with the deleted explanation, with the exception of urban areas. Overall, in terms of the energy chapter of the Hurunui District Plan, I consider the proposal is broadly supported for the fact it is a renewable energy proposal. I note the recognition of the national, regional, and local significance and benefits of renewable energy in Policy 7.1 and the acknowledgement of practical and logistical constraints of locating renewable energy activities in Policy 7.5. In terms of Policy 7.6, my opinion is that adverse effects have been minimised with the exception of the maintenance of visual amenity of rural character. I've also noted that Policy 7.7, which directs where any residual environmental effects of renewable energy activities cannot be avoided, remedied, or mitigated, the environmental compensation or offsetting measures can be considered where there are residual effects. I also noted through the course of the hearing discussion of the Waipara wine growing area in the Hurunui District Plan. And I agree with the commissioners that there is no specific objective or policy context to the Waipara wine growing area, and the assessment criteria which reference this area not relevant to this proposal given the rules breached in the rural chapter. I refer to the National Policy Statement on Renewable Energy from paragraph 283 in my Section 42A report. Consistent with my Section 42A report, I consider the proposal generally provides the benefits identified in Policy A. With regard to Policy F, I consider this policy needs to be read as a whole and in simple terms provides for an effects management hierarchy. I do not consider there are any Section 6 environments or values relevant to this proposal. I consider that adverse effects have been, where practicable, avoided, remedied, or mitigated. I note Ms. Allen has identified additional practical measures to further mitigate effects and agrees that these should be implicated by the applicant. However, I still remain of the opinion there are more than minor residual adverse effects in relation to landscape and visual effects, even with the additional mitigation proposed by Ms. Allen. The applicant has not proposed any offsetting measures or environmental compensation for consideration. In my Section 42A report from paragraph 358, I set out my weighting of the policy direction. I have concluded that aside from landscape and visual effects, all other adverse effects are able to be managed or mitigated through conditions of consent. As outlined earlier, in my opinion, in relying on the evidence of Ms. Allen, after where practicable, avoiding, remedying, or mitigating adverse landscape and visual effects, there remain more than minor residual adverse effects over the long term, in particular the properties on the western side of Mackenzie's Road, and to a lesser extent the properties on the western side of Glenmark Drive. Against this, I must balance the positive effects of this proposal, and in particular national significance of renewable energy, which I note the National Policy Statement on Renewable Energy recognises regardless of scale, although I consider this proposal to be of substantial scale. In my opinion, the positive effects associated with renewable energy, contribution to energy supply and resilience, reduction of greenhouse gases are at a national level. While I note the Waipara community will experience some economic benefit, in the absence of further evidence from the applicant, I would expect the economic benefits would likely be felt at a wider local regional level. I consider the ecological benefits of the terrace rise and revegetation would be a local benefit. In my opinion, the main benefits of this proposal are not felt at the level that the residual adverse effects are felt. However, the National Policy Statement on Renewable Energy is very clear that renewable energy is a matter of national significance and that this must be recognised and provided for. The National Policy Statement on Renewable Energy makes it very clear that decision makers must enable renewable energy assets and activities in all locations and environments, providing that adverse effects must, where practicable, be avoided, remedied, or mitigated. Therefore, on balance, taking account of the very enabling policy direction and national significance of renewable energy, I am persuaded the benefits of this proposal outweigh the residual adverse landscape and visual effects. Accordingly, my recommendation to commissioners is that this resource consent should be granted, subject to further amendments to strengthen the conditions. In terms of conditions of consent, I know caucusing with Ms. Alcamil to date, I consider these have been good discussions. However, on reflection over the weekend, I consider further work is required to strengthen these conditions. Ms. Anna has touched on some of this in her evidence. Given the high importance of the proposed visual mitigation and the uncertainty expressed around growth timeframes in the Waipara environment, I propose a further condition for a performance bond. I consider this as appropriate under section 108A of the Act. The performance bond should be worded to secure completion of the landscape visual management plan. I discussed with Ms. Annan, and we consider this to be tied to planting outcomes, such as the roadside screening and internal screening reaching 3 metre height within 5 years. The performance bond could also be tied to secure compliance with the construction management plan. I also consider it would be appropriate to include a conditional consent that no kennels are to be located within the Matagari exclusion area. Additionally, I consider it would be appropriate to add to the suite of decommissioning conditions that the site shall be decommissioned if the solar farm ceases operation for a continuous period of 24 months, and that maintenance of the site and the operational management plan must be adhered to not only during the operation of the solar farm, but until the site is decommissioned. I consider this as important to ensure that if for any reason the solar farm was to cease operation prior to decommissioning, that panel infrastructure would still be maintained to prevent any actual potential adverse effects arising. I consider further work is required on the grass height management condition to ensure this can be effectively achieved and monitored. And I'm happy to work with Ms. Alcmel to ensure robust conditions are available for the conditions that commissioners are minded to grant consent. I'm happy to answer any questions.
Okay, just first one, just going back to the NZTA situation, do you know whether they're committed to the 5 metre height of the boundary screening as part of their agreement, or is it just the shade cloth or whatever that was on the feeds?
I believe it would be whatever's required to.
So just going back to Ms. Annan's point of reducing down to 3.5, and it's just struck me that the NZTA's was their agreement subject to 5 metre height, or was it just the screening?
I believe it would be subject to the plans that they reviewed, but it was something that was discussed in our caucusing session on Thursday, the lowering of the height against the state highway, and myself and Ms. Alcamel did consider that we would need, if the height of that screening was to be lowered, we would need to check with NZTA.
Oh, okay. So
but we did feel that if it was lowered to say 3.5 metres and the panels have a maximum height of 2.77 metres, that this should be sufficient to mitigate any glint and glare effects, but that would need to be confirmed.
So first, State Highway 7, this Alpine Pacific touring route, is there any protection through the planning framework for that? So, you know, district plan RPS that you're aware of?
No specific that I'm aware of.
Okay. Would it be appropriate for us to consider the destination management plan in terms of section 1041C, you know, of the other matters? Do you think that comes into play in that context?
I was giving this some thought this morning. I think it would, as it adds context to the area, and section 104C does allow for consideration of other documents.
It's killed off 2 questions in one. You've confirmed that there is nothing in the district plan in terms of the Waipara wine growing overlay in terms of policy context. So that's another question I have. Is there anything in the district plan which identifies the site and the surrounding area as being sensitive, i.e. ONLs, ONFs, or anything like that? I think there's an ONL to the north, am I correct?
Yes, there's an ONL to the north over the Weka Pass area.
Yeah. And what about Mount Cass? Where's that nowadays?
I believe there is an ONL on Mount Cass. I would have to come back to you on that one to confirm.
It was commissioned was in 2009. We said it was an ONF. Is there a non-compliance in terms of the district plan in relation to that wetland area that was covered by, I think, ECAN?
In my section 95 report, I had identified that and included that as rules that were breached, but since then the applicant has applied to ECAN for resource consent from them for the earthworks within 50 metres of the wetlands. So I consider
it's been covered.
I consider it's been covered by the ECAN consent.
Right,
yes.
okay. And I just want to ask about, there was that resource consent to do with the Starlink gateway antenna. Is that still live?
Yes, so that was granted last year, so it is still live.
And where so exactly is it?
So it's on, so you drive along State Highway 7 and you sort of go up or around.
Up the
So
rise,
it's on,
up onto the straight?
Yeah, so it's on that rise there where you're going around the corner. I can send through a plan if that would be useful to show exactly where it is.
I guess what I'm interested in is what is it?
Yeah.
How high? What are we talking about here?
I can't remember off the top of my head. It's not massively high. It's a group of antennas, and they track the Starlinks in the sky. It's a while since I looked at the consent, and I can't 100% remember, but something I can look into and provide a bit more detail to you.
So it's essentially another piece of utility within that area alongside the power lines and the proposed Mount Cass power line and all that sort of thing down at that bottom end.
Yes, it's fairly low lying as well. It's not a tall structure either.
Okay. Is green planting permitted? So could you put a row of trees all the way along the state highway, all the way around the mountain? I know it may not be sensible, but could you actually do it?
Theoretically, yes, there is no specific rules. The only rule that we have in the plan is maximum height of 10 metres where it joins the road and neighbouring properties.
Oh, is that the shading issue?
I believe so.
Sure. Are you comfortable with the conditions where there's this potential duplication with the ECAN consent? Is that able to be managed? So I think what we're looking at is the construction dust. Dust was a good example where they're covered in programs. Are you comfortable that those conditions can be managed between district council and the regional council? It's not going to be duplication and overlap and that sort of stuff, conflicts.
I believe the purpose of the conditions from district and regional council serve different purposes. As for what that means for people working on the site, I've noted that the Environment Canterbury Consents don't have a construction management plan. They have pre-commencement construction meetings.
Is there any management plans in their conditions?
There's management plans in terms of avian fauna, lizards, but they only have a pre-start construction meeting. They don't actually require a construction management plan. And in terms of the dust measures that would be included in the proposed construction management plan through this consent, if it was to be granted, could incorporate the ECAN dust management for clarity.
Does some matter of interest, do the two councils have sort of arrangement when these issues arise between them?
Not that I'm aware of, but this would be a good example where it would be useful for, and given this will be a long-term compliance effort, it would be useful for the two councils to discuss and have a coordinated way to manage.
What's your view on the issue of the bond now? So I'm thinking of the post, you know, is there any examples where the council has previously required a bond in similar type circumstances?
The only one I can think of is for the Mount Cass wind farm. There was a performance bond on that which secured compliance with a number of things, and that did include decommissioning of the site, or does include decommissioning of the site.
So Mr. Cocker concluded that there were significant effects in the first 5 years on two properties, and Ms. Ennan gets as well, though she thinks it goes a bit further. So in your opinion, should this have triggered a Schedule 4 consideration of alternatives? Now, it's an interesting question because it's relating to two properties rather than perhaps the whole site. I'm just interested in what your view would be on considering alternatives in relation to two properties rather than the whole gambit triggering that. Just perhaps build on that. I'm trying to think myself what that might mean.
Interesting question.
I guess the question is, could a Schedule 4 consideration alternatives only consider two sites, two properties? And what might that mean?
Yes. I think that would be quite difficult to consider alternative sites if we're just looking at two properties. Potentially, and this probably does not come under Schedule 4, but rather than alternative sites, it could be alternative proposals on that same site. But I understand that's not what Schedule 4 is intending.
So you'd say, well, it would need to be, the whole thing would need to be significant to trigger the Schedule 4 rather than those two sites. That makes.
Yes.
Just a wee note for you, you can consider precedent under discretionary activities. Norwood versus Upper Hutt City Council. There you go. I know it well. I've covered all those. So just turning to the REG, and you obviously covered that before. So you heard my conversation with Ms. Makamal. There's just a few. You've covered most of them in your section 42A report, so I'm not going to go back over those ones, but there's a few that I just want to ask you about, mainly because things have occurred during the hearing, or you've got evidence now which you perhaps didn't have when you did your section 42A report. So first one is in policy A, which is 1C, where you originally said there were limited benefits to the Waipara community, and you sort of built on that a little bit. And I guess my question was, does your view change on that clause, given Mr. Andrews' reference to that approximately $10 million injection into the local economic spend in the first 2 years, and codifying some of that within the condition? You know, they've got that condition about the local people. And then there's also now this reference to 3 employees during the operational phase, so beyond the construction phase. So has your view changed on that at all?
It hasn't substantially shifted.
And then in terms of clause H, again on policy A, and I know you've referred to F in terms of effects, but one is actually about co-locating. So do you agree that the proposal does that in terms of the transmission lines in the substation? Agree that there's a co-location there between a solar farm and the substation and the transmission lines?
I think there is yes.
All right, tuning to F. So in terms of clause 1, do you consider it meets clause 1?
Sorry, can you repeat?
Sorry, policy F, the first clause, and policy F. Do you agree that it meets that, or do you consider it meets that? I shouldn't say agree.
Sorry, I don't quite understand it.
Oh, sorry. So if you just go, if you've got that one in front of you.
Yes, I do.
Okay. So I guess my question, I'm just going to run through each of them. So my question is, does the proposal meet that first clause in terms of what F1 or not, in your view? It's a bit of a generic sort of statement.
Yes, it does.
Yep. Okay. In terms of 2, is your position now that is no longer relevant?
Yes, I don't consider industry to be relevant to this application.
Okay, so turning to 3, what in your view is the weird practical bit? Is it simply a qualifier for the effects management hierarchy, i.e. avoid where practical, mitigate where practical, remedy where practical, or do you think in the context of this NPS it sort of waters down somewhat what might normally be expected in terms of the part to avoid, remedy and mitigate, which doesn't have the word practical? But what's your take on that?
I consider it waters it down. It's taking it from avoiding, remedying or mitigating to having to do that where it's practicable.
So it gives you an option to those. I mean, I guess this is new to, I know those words are being used quite a lot now on planning documents and clearly obviously in the new regime. But it is quite interesting to try and figure out what things actually mean in the context of this as we practical. So your view is it's a bit of a watering down on part 2. Now, in terms of policy F, where do you stand on the offsetting and environmental compensation? Your view, as I understand it now, is that it still doesn't offer those aspects. Is that correct?
In my opinion, the applicant hasn't specifically offered offsetting or environmental compensation.
Okay, turning to district plan, you've referred to chapters 3 and 7 as being the most relevant. So you agree that just the provisions in particular chapter 7 lend support to renewable energy. And you sort of covered off what I was going to ask you about is the sensitive environment thing. So I guess the question I was going to ask, which I think you've actually addressed, was the sort of the urban environment bit. So that when you went back and had a look through that, the urban environment was included in there.
Yes, it was.
Yeah, okay. That's interesting. In terms of those provisions then in section 7, so do you consider if there's a conflict between the proposal and the sensitive environments that has to be managed, so which is objective 7.1?
Given the proximity to Waipara Township, which if we are including that as a sensitive environment, yes, I think that is conflict that needs to be managed.
Is 7 point, so moving to policy 7.1 and specifically clause 2, do you think that's met now?
Yes, and that this proposal is not located in a sensitive environment itself.
And turning to policy 7.6, what's your view in relation to managing cumulative effects? Are the required setbacks from sensitive activities met? Are the noise emissions control, construction activities appropriately managed? And are amenity values and character maintained? I guess my question is, do you think they're met, or is there still a degree of inconsistency amongst some of those?
In my opinion, the first 4 would be met through strong, would be met in particular through strong conditions of consent, managing to ensure those are managed. I still believe there are residual effects in terms of amenity values and character.
So some inconsistency with that. And then the same issue again in terms of policy 7.7, which is the offset, environmental compensation offset. You don't think that that's been achieved or have been offered? So turning to the rural provisions, the project as it currently stands, the character and amenity of the rural area in terms of objective 3.1. View on that one.
So my view is that the character and energy values of this particular site are not maintained, but I consider the wider character and amenity values of the rural area are maintained.
And then turning to policy 3.5 and the various clauses here, I think in particular 1, 2, 4, 5, 6, although 6 is only in relation to State Highway 7. So your view on those ones?
So my view is that well, the proposal was a change in the character of the site, and it wouldn't, with the proposed shelter belt planting, with the proposed screen planting around the site, wouldn't maintain a dominance of open space, but once that has grown in, it would maintain a dominance of plantings over buildings, particularly with view from the State Highway 7.
And then policy 3.6 and specifically clause 3 is the one I'm interested
In my opinion, the proposal, in my opinion, the effects of this proposal beyond their boundary are controlled, with the exception of landscape visual effects.
And then turning to the recourse to part 2. Now, obviously, between you and Ms. Applon, there's a different opinion on that matter. My only question really would be, do you consider the district plan gives effect to the MPS REG as now amended? Probably the key in this space. Do you think the district plan addresses the REG? I know the district plan became before the REG, but is there enough in the district plan that addresses the REG?
In my opinion, there is. In my section 42A, I looked at the policy framework and I consider, while the MPS renewable energy with the changes has increased the strength of that policy, there's still general consistency between the provisions.
You've heard us talking a little bit around the extent of effects and the what could be changed to make a difference, and there's been some references to from some submitters to scaling down the size of this thing, and we've said, well, what if it was only on the upper terrace rather than on the lower terraces, and things like that. I think some submitters have said put it in the northern part of the site. What's your view on that in terms of the ability to consider that?
My opinion comes down to whether that's practical for the applicant, whether reducing the size of the proposal still meets the requirements for that proposal to go ahead. It would impact upon the positive effects of the proposal, but again, if that's decreasing the adverse effects, particularly in terms of landscape and visual effects, again, it's an exercise of weighting.
Do you think it's a more palatable option?
From what I've heard this week, yes.
done.
Yeah.
You heard Miss Kelsey this morning take us through quite a comprehensive thing about fire management, fire risk. What's your take? Where do we sit on being able to consider fire risk?
I consider that, in my opinion, fire is a risk, but it's a risk that can be managed through appropriate conditions of consent.
Do we have enough evidence in front of us to put that condition together?
In my opinion, there is a lot of evidence. In my opinion, the applicant has provided evidence in terms of fire risk. I believe it would be useful for the applicant to provide information that has been developed specifically for the Waipara site, rather than relying on evidence that has been written with another site in mind. In my section 42A, I did consider that they presented 5 scenarios, and 4 of them related to solar farm infrastructure and fires starting within that infrastructure, and the 5th one was around grass fire risk. In my opinion, the first 4 scenarios could be applicable because they relate to equipment and fire starting within equipment, but the grass fire risk, in my opinion, it would be useful for there to be further consideration given to this.
And do you think that's a deal breaker in terms of granting consent or not?
In my opinion, it can still be managed through conditions of consent.
We've also heard over the last week a lot of consideration about tourism effects from splitters, but we don't have any specific evidence about tourism. We don't have any economic assessment of tourism or social impact that related to tourism. Do you think that we needed that, or is it covered in other things?
In my opinion, consideration of tourism is a subset of landscape and visual effects.
You've covered everything else.
Okay, thank you.
Thank you.
We'll just take call now, and hopefully we can come back and ask some questions of the applicant. Liz, are they online? No?
Yes.
Okay, cool. So we'll just take 15 minutes and then we'll come back to the questions. Have we got Mr. Ibbotson online? Ibbotson, can you hear us?
I can hear you.
Great. Okay, we've got a few questions for you. Did you hear Mr. Trevathan earlier on?
Yes, I did hear Mr. Trevathan.
Okay. So we've just got a few questions that we just wanted to ask you. Firstly, just give you an opportunity to respond to anything that he said before we sort of get into those questions.
No, I thought his advice was very good, clear, and I didn't have anything significant to add.
Yeah, one of the issues that has risen during the hearing is the fact there's been a subdivision granted on the northern boundary of the site.
Yes.
You may not have been aware of.
I've been made aware of it, and I have seen some drawings that show 2 lots along the northern side, as you've just said.
Yep. Now, Mr. Trevathan said he was, in his view, that the contour around that area was inside the application site. Can you confirm that that's correct?
Based on the noise predictions in my report, the noise level should be below or at around 40 decibels along that very northern site boundary. So noise levels would not be above 40 decibels based on the inverter positions that I used in my analysis.
It wouldn't be above 40 or 45?
Wouldn't be above 40, and it also wouldn't be above 45.
Turning to the so-called reverse sensitivity condition, I think Mr. Trevathan's view was that it wasn't necessary given that any dwelling that might eventuate inside that 80 metres would be subject to NZTA requirements anyway. Are you still the view that it's necessary or not?
If it was taken out, and if the condition that references the existing dwellings, that the noise limit that is requires noise levels at existing dwellings to be no more than 45 decibels LEQ, combined with the fact that we have very strong likelihood that any dwellings constructed near to the road, if they ever were, would likely need to have facade sound insulation, then that can serve to protect the solar farm and will provide an appropriate level of sound insulation to dwellings, or appropriate level of noise inside dwellings from the solar farm as well. So in short, I'm comfortable with 102 being taken out, but it does rest on condition 101, I hope I'm getting these numbers correct, remaining applicable only to dwellings that exist at the time the solar farm consent is granted.
That's what it says. No.
Yes, I think that is what it says at the moment, yes.
Would that then be problematic then for the Antle Young subdivision, because they are not existing even though there's a subdivision consent? And there would be no,
it's actually good. I'm sorry.
There'd be no requirement noise for that property or those 2 properties.
This is where it might become a matter of discretion for the person who's looking at the consent. The subdivision is in place. It doesn't appear to me that there's a nominated building platform, and I expect that there isn't a building consent granted for a dwelling. So it may be that the interpretation of the consent condition that's proposed, i.e. that it refers to existing dwellings, wouldn't include any future dwellings that are intended to be constructed there at some time. So there wouldn't be a limit that would apply to those future dwellings in that case.
On that site, obviously, they would still be required to set back 80 metres. So assuming that it was beyond 80, any dwelling was beyond 80 metres from the highway. The highway's on that side of the road as well. With your view is though that the planned standards would still be met, is that correct? Because the closest inverter is some distance away. Is that the scenario?
Yes, they'll be met with a good margin of compliance. So the dwelling would need to be 80 metres from the highway, and there'd probably need to be some offset from the boundary that was shared with the solar farm. It may not be huge, but there may be some offset. So the noise limits that are in the district plan can be achieved.
Yeah, we did have a concern that we just asked earlier about traffic noise during construction, and just trying to understand whether a large number of small vehicles on the site. We read a report that NZTA, I think, has been involved with. It said maybe up to 90 vehicles on the site at any one time, whether that has an impact on noise assessment during construction.
You don't need to be concerned about vehicle movements on the site during construction. The distances are such from the dwellings that the numbers of heavy vehicles movements that I've included in any realistic number of light vehicle movements that could occur on the site will be very significantly below the construction noise guidelines, will be entirely reasonable. Just a simple comparison is to consider the fact that a small number of light and heavy vehicle movements moving at low speed across the site, when compared to a much, much larger number of heavy and light vehicles moving along the state highway, that there'll be orders of magnitude differently, i.e. the noise level from vehicles moving on the solar farm site will be orders of magnitude lower. It is possible that someone may hear a vehicle movement on the site at times, but it's unlikely to cause any kind of noise effect that needs to have any concern about.
You probably heard us asking Dr. Trevathan about staging construction. What's your view on that?
My view is that my observation is that the construction moves very quickly. The contractor will lay out the piles and proceed to construct along, I guess, it's not the right word, but they will lay out the piles and proceed to construct an area, and they'll do that very, very quickly. It's in their interest to do so. I don't see that there's any real benefit about providing some kind of prescriptive constraint to a contractor about where piling should occur. I think it's better to leave that to them. On other solar farm construction sites, people have raised concerns that perhaps the closest pile to them might be driven at 7:30 in the morning, and they would prefer that not to happen. They would prefer that, for the closest period, for the closest day when piling is occurring, they would prefer that to occur later in the day, perhaps 9 o'clock. So in my view, managing construction noise from piling comes down to good communication with neighbours and taking a neighbourly approach to those early morning starts. Best place to do that is through a construction noise and vibration management plan.
And then my final question for you was, do you think it's acceptable to have noise from construction over a 2-year period in a rural environment such as this, given the proximity of neighbours and the Waipara town?
Yes, the majority of these works aren't going to be particularly loud, and they're not going to be intrusive. As I think Jeremy Trevathan said, Dr. Trevathan said, it is the piling really which should form the focus for any decision making over effects. That activity does create noise. It moves quickly. I believe the duration here is in the order of 5 months for piling. Might need to check that to confirm. But it's, as I understand, it's certainly not over the entire 2-year period. So people will experience times when piling noise is higher, and then obviously as the piling rigs move further away, noise levels will drop and drop considerably when the piling rigs are further from dwellings. So I believe it's okay. It's acceptable. It's within the scope of the construction noise standards. It happens on other sites, and so I don't have significant concerns about the effects.
Okay. Thank you. Those questions we have for you.
Thank you.
Can we go to Mr. Cocker next? Mr. Cocker, can you hear us?
I can. I should be visible now.
Yep, we've got you. Okay.
Right, we just have a few further questions for you, Mr. Cocker. Appreciate you being available all of us last week, so you would have heard most of the submitters, and I also understand from Ms. Annan that you have now visited a number of those properties that you hadn't visited at the time of your assessment and your evidence. Is that right?
No, I think you misunderstood there. I visited the properties, a number of the properties, some months ago, late last year, I believe it was, or early this year. So prior to preparing my evidence.
Prior to evidence.
Yeah. I mean, when I say visited a number of the properties, I visited representative locations where I was able to get access to, one of which was next door to one of the submitters' properties, which I assessed as being high temporary effects.
Okay. So we have visualizations from 247 and 251, I think. So you didn't take those photographs?
No, that was the photographs were taken. Well, the photographs for the visual simulations were taken by Virtual View, the people that prepared the visual simulations.
Okay, so really your assessment on the two properties that Ms. Annan has identified as high, it's not based on a site visit to those properties, but it's based on the visual material by Virtual View and on your visit to a neighbouring property.
Well, when I say the neighbouring property was I was on the fence line of the property in question.
Right.
So in effect, it would have, yeah, the view was comparable, certainly.
Okay. You would have heard during the week, a lot of the conversation has been about the potential success of planting.
Yes.
And then Ms. Annan reached a conclusion that trying to define a length of time in which that planting will become effective is too difficult. What's your take, and where, based on what you've heard over the last week, what you've heard from particularly the ecologists and people experienced with growing and irrigation in this environment, where do you land in terms of planting rates and opportunity for success?
Well, I mean, I think you certainly heard a lot of people explaining the difficulties that they have experienced with planting on their properties. Also heard some slightly contradictory statements which suggested the shelter belt planting was perfectly practical and could be achieved. I've obtained a statement from Andrew, from the owner of Riverside Nurseries, which we will be presenting as part of the right of reply. And he sets out, well, many of the observations that I made in my evidence in terms of growth rates and planting methodology and the mitigation that is available and whether that's appropriate and sufficient. So I will that statement will be supplied to you.
Okay, so with that information which we'll be receiving, you indicated to me when we talked last that you thought it would be it would take longer than 5 years for that planting to become effective. You suggested probably, I think you said maybe another year, so that would be up to 6 years. Do you still hold that position?
Well, I think in that discussion was in relation to the visual simulations from the state highway, which I think said 3 years and showed vegetation at a certain height there. Just incidentally, I heard you talking when you were talking to Ms. Allen today about those visual simulations. You were positing that the vegetation shown was 5 meters. It's actually modelled at 3 to 4 meters in those locations. I mean, I think what's shown in the visual simulations is probably representative of around about five years, I would say.
Okay, so that's different to what you told me a week ago. What you said it would be just a bit longer than 5 years.
Well, I said, well, I just said round about 5 years, so 5 years and thereabouts, yes.
Okay. And do you have any thoughts? Some of that discussion has been on the resilience of planting in shelter belts, particularly along straight shelter belts. Do you have any views on that?
Well, again, I'm informed by the expert from Riverside Nurseries, but I mean, I would note that a lot of the boundary plantings are going to be that shelter screen which is being erected when the fences go in will provide some wind protection for those plants when they go in. So I'm given some comfort by that.
You mean the shade cloth?
Yes, that's right. And just to, I mean, I think when I was given my evidence last time, I felt there was some misunderstanding about the terminology that I was using. There's three types of planting which will be treated differently. There's a boundary screen planting, which is on the boundary. There's the internal screen planting, which is generally along the top of the terraces. terrace rises, so at the crest of the terrace rises, and then there's the revegetation, and the revegetation isn't really anticipated to provide much visual mitigation, not for a long time. So I just thought I'd probably need to clarify that terminology that I was using.
That's helpful, thank you. So if we have a look at your joint witness statement and the agreed table of findings, as I did with Miss Annan, can you explain then what do you mean by short term and what do you mean by long term in that table?
I'm just pulling up the joint witness statement. And short term, I'm considering to be year 1 through to year 6 or 7. And then long term is beyond that.
And if the growth rates and the vegetation is not successful, if it takes longer, would you agree that the short-term effects would also last for longer?
Well, they would, but I'm reasonably confident about what I'm relying on in terms of the growth rates.
So if we were to just go through that table, I want to focus on Stateway 7 to start with. There's quite a difference in terms of your assessment at low moderate compared to Miss Annan at moderate high, and then you drop to low and then she drops to moderate. Can you give me any reason why you think that Miss Annan would be higher than what you have assessed, or why are you lower? What drives you to be lower?
Well, I guess I'm relying on the screening provided by the screen cloth that's on the security fence. That will screen views of the panels within the site, albeit you'll be afforded glimpse views through the entrances, as Miss Annan mentioned.
But one of the things that Miss Annan talks about, and I think you would have heard this a lot from the submitters last week, it wasn't just about the visual effects from the highway or from other places, but also other perceptual effects and associational effects, that idea of understanding what the solar farm is and it being there. What's your take on that?
I mean, I think that's certainly a more significant consideration with respect to the residential affected parties compared to people arriving heading towards Waipara along the state highway. You'll experience views of the valley as you drop down from the Weka Pass, and I think just your first views into the valley occur as I think there's a pull-off on the side of the road, which I don't know if it was put there deliberately for providing views to the valley floor, but you certainly get views to the valley floor from there. But then beyond there, you drop down and the views into the solar farm will be screened by the shade cloth initially, and then by the planting in the longer term. And though I been at the as was discussed earlier on, at the moment, you do get views across the valley floor from as you're passing the southern end of the site, but as you get towards the central and the northern ends of the site, those views across the valley floor are curtailed by shelter belts either along the side of the road or perpendicular to the road, they occur repetitively, and so your view opens up and then it's gone again, and you lose the view of the hills due to those shelter belts.
Okay, yeah, I understand the visibility aspects. I think what we've heard from the submitters and what Ms. Annan was getting at was that there's more to it than just seeing things, that there's a wine character and a rural character that's broad across this landscape. So are you saying that perhaps from a visitor or a tourist perspective that they don't get to appreciate that because they simply just won't see the solar farm?
Well, no, they do get to appreciate it, because you can see as you're going along that road, you look to the right hand side, and there's vineyards there. So I mean, there's still that awareness of that land use and of that character along that road, which you can appreciate from the road. You're looking to the right, you experience that spaciousness, and if you're looking slightly back, the views to the Deans and across the vineyards there.
Okay, if we then turn to the Mackenzie Road properties, that's 251 in particular and 247. So I see that you now you confirm that those effects on those properties will be high at construction and for the first 6 to 7 years.
Yep.
And then they drop quite remarkably down to low. But having been to those sites and having been to the neighbour's side and looking down on those panels, they'll still have quite an extensive view of panels from those properties, won't they?
Well, I mean, they will, and over that time, over that duration of the 6 to 7 years, the visibility or the panels will be softened. But as I explained when I was giving my evidence, over that time, as the vegetation grows, you're not going to totally look. Well, as we've discussed at length, you're not going to lose or have those views of the panels screened, but the planting, the internal screen planting and the revegetation planting will form that framework, which will soften and fragment views of the panels. And so in my view, that softening and fragmentation serves to mitigate the level of effects. And over time, that will go down to the level that I'm suggesting.
No. Just go back to State Highway 7. Miss Hannon talked about potentially lowering the height of the shelter belt or the boundary screen planting from 5 to 3.5 metres. Have you got a view on that?
Yeah, I mean that was we discussed that together, and I mean so long as that doesn't affect the Wakatahi's view on it, or doesn't affect the glint and glare assessment. I mean, I'm in favour of reducing the height of the screen planting along that frontage. We also we talked about a number of other things, and also such as, and I think as Mazanan talked about, including some taller grades in key locations. One of those locations would have been approaching for the south on that southern end of the site. So introduce some taller plantings there, and also potentially on the northern end as you're approaching on the state highway from the northern end, including some taller specimens there. But after the hearing on Friday, I went up and had a look at the subdivision that we heard about, and I think potentially another approach, another slightly different approach could be used on the boundary of the shared boundary of the subdivision and the solar farm there, where you might look to include some taller exotic specimens, include some exotic plantings, but also introduce some native plantings as well, so you get a little bit more amenity and less of a utilitarian interface between that lot. I think it's lot 2 and the solar farm, and the height of that planting, potentially, again, so long as it's acceptable to Wakatahi and still works with the glinting glare, you might look at maybe reducing the height of that planting a little bit more, so that from those lots you still get views out to Mount Cass.
So is that something we can expect in your full writer reply, to have all of that confirmed?
I mean, I think the detail of that will need to come through in the landscape management plan, and we need to work through, and I can document what I've just spoken to you, if that will be helpful. But it also needs to be provided for under the condition of consent, and we're still kind of working on how that gets drafted. Okay, and then my final question is, you will have heard we talked to a couple of submitters and also to Miss Annan about if the scale of the proposal was reduced, and I think probably particularly taking, considering not going forward with panels on the lower terraces and restricting it just to the higher terrace, would that make a marked difference in the effects on neighbouring properties? Well, I mean, you're reducing the visible scale of the development, and as was discussed earlier on, taking out those lower terraces the lower terraces tend to be more prominent because some of those properties are looking, albeit slightly, looking down onto them. So those lower terraces, not only being closer but also looking down onto them, assume a greater prominence. So if it's just reduced to the higher terrace, closer to State Highway 7, or you can see in the visual simulations, those tend to be seen as a narrow band because you're looking at a similar level, they seem to be viewed as a narrow band of panels, and also it will be easier for the planting or quicker for the planting to screen them and probably be more effective. So I think the answer to your question was yes.
Yes. Okay. Thank you.
Can I just got one question for you. What level of effects do you consider between, say, years 5 and 10? So if we take those properties at 251 and 247 Mackenzie's Road, so you've said high in the short term, which I've taken to be sort of 0 to 7 years, and you get to low in the long term. What's the medium term?
Well, I guess When you were questioning me in my when I provided my primary evidence, I did talk about that the perceptual nature and the shifting perception, and so it really depends on that, and it's going to vary from individual to individual whether they become more accepting of what's there. But I guess just on a kind of a, putting it bluntly, I would anticipate as the planting grows just to have that gradual tailing off of the level of effect. So
So would we be talking, say, a moderate effect in that medium term? Would that be fair?
Yep, probably yes, I'd say.
I mean, we heard from the owners of those two property occupiers of those two properties. We heard their opinion on the perceptual effects of the solar farms. I think they were quite clear on it.
Yes, yes. No, I agree. We heard, but I think it's worth bearing in mind that is a factor as well.
Okay, look, thank you, Mr. Crockett.
Thank you.
I just wondered whether we can go to Mr. Andrews, please. Good afternoon. Can you hear us? I think.
Can you hear me? Sorry.
Yeah, we can hear you now.
Thank you.
Thank you. Thanks, Mr. Andrews. So we just got a few questions for you. Firstly, did you consider undertaking a social impact assessment on this proposal at all?
No, we haven't considered. We haven't done a social impact assessment. No.
But you did. You didn't consider doing it at all?
No. No.
We just got some confusion over anticipated traffic numbers, and I wondered if you could just correct us on or give us a better understanding exactly what we're looking at, because I think your report says it's 6 vehicles per day, but there are other reports too much more than that. Can you just give us some clarity on that, please?
Yes, we did a traffic impact assessment, which was based on experience at other solar farms, and in particular, another solar farm that we've developed in the North Island. And most of the focus of that was on the heavy vehicles. And we did a analysis across the time, found the peak vehicles to be around about, well, under 6. So we went with 6. We went to NZTA with, I believe, the number of 6 heavy vehicles on site per day. So 6 deliveries per day is the terms we've tended to use.
But that's just the heavy vehicles. So
Yes.
There'll be a whole lot of other vehicles on the site during construction.
Yes, there'll be a number of light vehicles. There'll be staff, depending on where the staff coming from, whether and how long they're there. We would normally, because of the simple fact that you don't want that many vehicles parked on site, we tend to arrange, or the contractor arranges to carpool or bus their own staff onto the site, just to keep the numbers of vehicles parked on the site down. I think it also stops works on work times and stuff like that. People don't leave early or arrive late.
Okay, and can we just confirm then that, so in the NZTA assessment, they have considered all of those vehicles, all of that construction, both light and heavy vehicles? And all
yes, they were provided with those numbers, yes. And they commented on them, yes.
Mr. Cogger just made reference to a report from Riverside Nurseries. I wondered, is there any chance that we might be able to have that relatively quickly?
Yes, I believe it's with Mr. Cocker as presented, but he has it available, I believe, and he could hopefully send it to you today.
That would be great. Thanks.
Yeah, I'm thinking if we can have it ahead of a right reply, it might be useful.
Absolutely. Yeah, they have been on site. They have evaluated. So they did provide Mr. Cocker with a large amount of the background to his evidence and with his own experience, and Mr. Dartnell.
Just finally, are there options to reduce the scale of the project if we found that the effects of certain aspects of the proposal were too great?
Yes, there could be. We've done that once.
I'm not saying that we have found that yet.
No. I understand. It's a scale where it goes into the model, which for investors and developers. We've redone that once recently. The site and the costs around the site depend mainly on the cost of connection. That's why we've sought that site to reduce the cost of connection, but it's still a very major contributing factor, and that needs to scale in order to work back towards the cost of Transpower will charge us to connect. So it's not impossible. The second part of that is it would be interesting to choose where to reduce the costs, where to reduce the capacity. If you reduced it in some areas, to keep some people happy, but not others. But we could always look at that and put it back into the model and see if it still works. We wouldn't want to move closer down towards. We wouldn't want to change the design in terms of getting any closer down to Glenmark Drive, which is why we just went slightly further towards Wicker Creek and did the bund to protect it in the event of a flood. But nothing's impossible. As you've heard, there's a lot of everything in the solar farm, like any business, is a factor of multiple things coming to a balance point, and we'd be happy to re-evaluate that balance if we needed to.
Okay, thank you. That's all the questions we've got. Oh, sorry.
Thank you.
Oh, sorry. Yes, you might have heard this morning, I don't know whether you're on all day, but Ms. Kelsey has referred to the fire report from REG and the conflict.
Yes.
Is there a conflict there, in your view?
The people, the guys that wrote that paper are fully qualified engineers across a spread of different disciplines, and quite a lot of them have renewable energy as either a postgraduate or other secondary degree to their basic engineering degree. So those are skilled people who work very closely with the fire engineers of Becker and went through the process and learning with the Becker engineers. And that gives them, in good engineering practice, it gives them the ability to translate one situation to another situation with the skill and diligence that's required. And I believe they did that very carefully, and considering the comment was, grass fires are grass fires. How do we minimize grass fires? The equipment's much the same. The environments, we did carefully consider, I had discussions with them. They wanted to know about the two different environments in terms of wind, rainfall, and stuff like that. But the big issue came down to the fuel loadings under the panels. And if the fuel loadings under the panels can be maintained, from the understandings of their discussions with Becker and looking at the research that they've done, is that if you can reduce the fuel loadings under the panel, you reduce the chance of anything catching fire in the panels themselves, and the grass fire can move quickly through the grass and be extinguished either with water at the end or before it gets in there. But you could even have the fire run through parts of the solar farm to the fire breaks, where they could be controlled by water without catching fire to any of the materials on the solar panels, because it's very, very unlikely to actually set fire to a solar panel because there's no flammable material. So rather than have them doing heat damage and wreck the panel, the understanding was that a short fire duration at low energy would not damage the panels. That was transferred from the understandings at the Greytown solar farm, and they applied it to Waipara, which I think is a valid transfer, and they did that with due diligence and thought, I believe.
The issue here is around a conflict of interest.
Oh, sorry. Okay.
Between REG as directors of REG and Farnell Solar being the same people. So it goes to the credibility, I guess, of that report.
Yep.
Got anything you want to come back at us on that?
I'm not a director of those companies. I'm an employee. I believe those engineers perform their tasks as professionals with their due diligence, but they certainly do have the same effective eventual owners. You're right. That's true.
Would you as applicant be opposed to us getting that report peer reviewed?
No, I don't believe so. That would be good.
Okay, we didn't have any further questions for Ms. Akamal, so we can leave that there. So
I've been trying to get hold of council and we can't get hold of her for some reason. So I hope that's not the next thing, sorry.
Well, we'll just have to leave that at the moment, but what we want to do is adjourn the hearing at this stage. We want to take a few days to actually consider what we've got in front of us before we get a right of reply. We would like that report that Mr. Crocker has just referred to, but we want to take a little time just to go through what we've got, and we'll have a look at this whole issue around the fire thing, because most of that's come up today and we haven't had a chance to have a really good look at that. So we just want to take a few days and just adjourn the hearing. We have been asked to do another site visit, which we need to make a decision on as well. So we're going to take probably around 5 days to have a look through the information and then issue either a minute or some directions from that. That may be for the applicant just to provide their right of reply, or it may be that if we want to get anything reviewed or peer reviewed, we'll do that. But we just need a bit of time for the two of us to sort of get together and have a good talk about some of this stuff. So at this stage, we're going to adjourn the hearing as of now, and we will issue some directions over the next week. So thank everyone for your time. This will likely be the last day of the hearing, although you never know, things do come back again. Look, I'd like to thank SMITIS for all the time that they spent and the information they put forward to us. Thank council staff for all their guidance and help during the process, and thank the applicant for your time as well. It's been a long week, and we've got a lot of stuff to look through over the next few days and over the next few weeks. So thank you everyone very much for all that.
Thank you.
The hearing is adjourned. Thank you.